Mr. Solomon.
May it please your ladyships, I appear for Verition, the appellant and the second defendant in the underlying claim.
Yeah.
Mr. Craig, King's Counsel, appears for the claimant and respondent, leading Miss Judy Stone for jump. Mr. Couture, the first defendant, is neither present nor represented, but his counsel, Mr. De Silva, has put in a short skeleton argument supporting argument.
Yeah.
My ladies, if I may briefly address you on housekeeping matters, your ladyships should have a core bundle and a supplemental bundle which was updated on the 5th of June, now running to 276 pages, hopefully.
Just check. No, mine goes to 253.
May I hand up?
Goes to 276.
Oh, okay. Well, the update has not reached me. Is there a document that's very important at the end?
Yes.
Yes.
The judge's approved transcript of the judgment, which I think both...
Oh, I read that, so I must have it somewhere. I must have it loose.
And would it be helpful if I handed up the clip?
Could you?
Yes.
I read it, but it wasn't in the bundle.
So I'm handing
and I've
up,
left it on my desk.
I'm handing up an updated index
Thank
and
you.
254 to the end.
Thank you.
There's also an authorities bundle.
Yeah.
It's large. Apologise for that, but
Yes.
that was filed in accordance with the directions for the date for authorities. Last week there was some more authorities provided by the respondent.
Yeah.
And last night we got some more from the respondent, but they may or may not be handed up.
Yeah. Okay.
And your ladyships will have skeleton arguments from me and my learned friend and Mr. Couture.
Yeah.
I did an updating note at the end of last week,
Yep.
On Monday, in fact this week, on recent events. Typically with this case, my ladies, that note is already out of date since there have been further events. Most notably, yesterday evening, we received 2 further applications from Jump, one for a split trial and another pair of applications for specific disclosure against both defendants. Your ladyships will be grateful that these applications haven't been put before you. I'm holding them up here just so you can see the weight. I haven't read them in any detail yet, but it's relevant to the matters your ladyships are considering, the approach that the claimant is taking.
Why is it relevant?
Because we say it was always obvious, or should always have been obvious to the claimant, that it was seeking a split trial in various ways. And had that been made clear to the judge, he would never have ordered a speedy trial.
Really? Why? Liabilities presumably will be tried first if there's a split trial, and that will determine whether there's to be an injunction or not. And if there is to be an injunction, that's the end of it. If there isn't to be an injunction, what's left?
The claimant has applied to amend,
Yeah.
and there are different liability claims it now brings. It doesn't seek injunctive relief anymore against my client, as far as I understand it, or at least in its amended claim. And so there is to be a further hearing on the claimant's case for liability after the speedy trial. And if it wins in the speedy trial, there might well be a remedy hearing relating to the interim period where Mr. Couture is working for the first defendant. So there might be a whole series of further hearings after the speedy trial.
Right. Okay. Well, you'll come to that. Doesn't seem to me to make much difference, but anyway.
Okay.
So there's split trial and disclosure applications.
Yes.
Okay.
In addition to the amendment application next week. I would say that the claimant's conduct, the way in which it's proceeding, it is undermining the speedy trial which is due to take place at the end of this month. what I intend to do this morning, with your ladyship's permission, is very briefly underline the key dates in the chronology of this case, which are relevant to whether there's an order for a speedy trial. Deal briefly with the primary points on discretion, those are grounds 1 to 3, and then ground 4 in a little more detail with reference to some law, because that's a slightly different...
That's the serious issue to be tried point.
Exactly, which is necessary, we say, for the judge's conclusion on speedy trial. Mr. Craig and I spoke yesterday about timings.
Yep.
I suggested that we might finish oral submissions before lunch, and he said that would be a bit optimistic, but let's aim for that at any event.
Very good.
So perhaps submissions of somewhere in the region of an hour to an hour and a half from each of us, and short reply from me. First, the chronology, if I may. And I'm going
You
to...
can take it relatively quickly, Mr. Solomon, because we've read all the papers and I've got certainly a pretty clear idea of the dates.
I will take it very quickly. I'll take this very quickly. I just want to highlight a couple of key dates. And I'm going to do this from Jump's own evidence before the court. And that can be found in the supplemental bundle, Mr. Diener's first witness statement. It starts at page 1, but I'm going to pick it up, if I may, at page 14 of the bundle.
Yep.
Paragraph 31, the 30th of March, Mr. Couture gave notice.
Yep.
Paragraph 33, on the 12th of July 2022, he informed Jump that he intended to join Verition. Paragraph 35, on the 17th of November 22, he wrote a letter to Jump saying that he intended to start on the 3rd of April 2023, almost 5 months later. The claimant then did nothing.
In this period, he's on garden leave,
Yes.
serving out his notice.
Yes. The judge notes that there was no communication between the parties in the period, and the claimant accepted in the hearing below that there was no explanation for this delay.
Yep.
And then paragraph 36, only on the 6th of March the following year, 2023, this year, the claimant wrote to the first defendant saying the non-compete was enforceable, and 37 over the page at page 15, the first time that my client Verition was contacted was the 16th of March, a couple of weeks before Mr. Couture was due to start. 8 months after he had informed Jump that he was going to work for the second defendant. So those are what the judge found were the stark facts.
Yeah.
Just going forward in the bundle a little, if I may, to see how the claimant puts its case. Your ladyship's turn to page 17 of the bundle, paragraph 44 of the same bundle, the same witness statement. There, Mr. Diener is talking about what will happen if the injunction isn't granted. He says, if the injunction sought is not granted, and Mr. Couture commences work with Verition in breach of the non-compete covenant, potential harm to Jump's competitive position if he uses its confidential and proprietary information in that role is likely to be immediate, substantial, irreparable, and impossible to quantify.
Yep.
Taking that forward, he wrote a witness statement in support of the application for permission to appeal to the Court of Appeal, his third witness statement, and that starts at page 108. But if I can pick it up at page 111 of the supplemental bundle, read paragraph 9. He says there's a very high risk that Mr. Couture will use Jump's highly valuable confidential information to further the interests of Verition. The potential harm to Jump's competitive position if Mr. Couture uses its confidential and proprietary information, even inadvertently, in his new role is likely to be immediate, substantial and irreparable, same phrase again, even if Jump receives a later ruling prohibiting Mr. Couture from working for Verition, it will not be possible to unring the bell and untell others at Verition the information Mr. Couture will inevitably provide.
Presumably that was all on the basis that he would be doing the quantitative trading role using the
Yes.
algorithmic data.
Yeah, that's Jump's case is that he will.
But as I understand it, from what the judge says, Mr. Couture says he wouldn't be doing that
Yes,
for the first
that's
year.
right.
He would be doing something different in the first year that
That's
wouldn't require the use of that information.
That's right, my lady.
So
I'll
that
address-
position has changed. It will not cause immediate irreparable harm.
Well, the position is that Jump's evidence before the court
That's Jump's evidence.
That's Jump's
But you
evidence.
don't ignore what Mr. Couture says
No.
about what his role will be
Exactly.
at Verition.
Exactly.
Okay.
Your ladyship has the position absolutely that Mr. Couture's evidence is, for a year, I'm not going to be competing.
Yes.
And so there'll be no
And
damage.
the judge was entitled to rely on that.
Yes.
Right. Okay.
He was entitled to rely. I'll make
Right.
submissions on that in a moment.
Yes, I'm just confused about why you're going on about that when Mr. Couture said something different.
Well, there are 2 points. First, it is Jump's position that there should be a speedy trial, yet its evidence is there will inevitably have been damage already. And
Well, that was on the understanding that Mr. Couture would be competing immediately, but we now know that Mr. Couture was going to do a different sort of a role for the first year.
My lady, this witness statement was written with the knowledge of Mr. Couture's evidence. So this is the third witness statement after the hearing
Okay.
before the judge, where Jump maintained the position, notwithstanding Mr. Couture's evidence, that damage will be immediate and inevitable.
Well, but did Jump accept Mr. Couture's evidence about what he'd be doing in the next year or not? I mean,
No.
it rather sounds as though they didn't. So
They
I
don't
just don't
accept-
see where that point takes you. And there's a further point, which is that the fact that Jump was saying then, on the premise that Mr. Couture would start competing immediately, that they'd suffer irreparable and immediate damage, does not exclude the possibility that they would continue to suffer damage if he continued to compete with them. Does it?
Well, the evidence from the parties was at odds with each other before the judge. So Jump's evidence before the judge and after the hearing before the Court of Appeal was that there'd be immediate, inevitable damage. And Mr. Couture's evidence was that he would not be competing for a year. And what Jump said in its application for permission to appeal was that the judge was perverse to accept Mr. Couture's evidence on that point. And I'll show you that in a moment.
But does it matter? We're not re-examining that appeal.
No.
We've got a very narrow focus. Was the judge right, or on your case, was he plainly wrong to order a speedy trial? It's a high threshold.
Yes, I accept
It's a case management decision.
I accept that fully.
That's our focus.
And so the Jump's position has always been that it was perverse to take this into account. Our position is that if the judge was right to accept Mr. Couture's evidence that for a year there would be no competition, there was no point in ordering a speedy trial.
There was
because-
every point in ordering a speedy trial.
Well, with respect, if there was no competition for a year, that would be the end of the covenant, the maximum covenant period. And so if it's right that there was no competition in that period, there would be no damage to Jump. So picking up the chronology, my ladies, the employment, Mr. Couture's employment terminated at the end of March, and even then nothing happened with any alacrity. After some procedural hiccups, proceedings were issued by the claimant on the 14th of April, and particulars of claim served on the 18th of April. And the application for interim relief came on the 28th of April, and the approved transcript of that is at the back of the supplemental bundle at page 265.
Yes, thank you.
And your ladyships will see that at paragraphs 13 to 18, pages 267 to 268 to 269, the judge dealt with the facts that I've just highlighted. And you'll see at the bottom of paragraph 16, he says, there was no reply to that letter, that's the 17th of November 22 letter, until the 6th of March 23, and in fact it seems there was no communication at all between the parties during this period. There is, as Mr. Laddie for Jump frankly accepted, no explanation for the almost 4-month gap of time before the 6th of March. The serious issue to be tried test was considered by the judge at paragraphs 23 onwards. At paragraph 47, I'll come back to that when I address your ladyship on that in terms, but at paragraph 47, the conclusion is that there was a serious issue to be tried, but the defendant's arguments are stronger, 3 lines from the bottom of that paragraph. There was no serious issue to be tried, on the other hand, in respect of the inducement claim against the second defendant, paragraph 50. The judge refused to order relief, however, because of delay. And paragraphs 43 to 47 dealt with that. Paragraph 44, it says, 44 and 45, there are 2 critical issues. The first is that if an application had been made earlier, an expedited trial could have been arranged, so resolving definitively the issue between the parties. And 45, there's a possibility of arbitration because there's an arbitration clause in the contract. Of course, if there had been an arbitration, that would have removed entirely the question of prejudice to other court users, which the case law says is something the court must consider. In his judgment on the permission to appeal application, Lord Justice Bean also noted the striking delay. And for your ladyship to note, that's page 87 of the core bundle. At paragraph 52, we come to the judge's reasoning on expedition. And the second half of that paragraph was not in the extempore judgment, or the claimant's agreed note of the extempore judgment. What he said orally is recorded by the parties in the core bundle at page 73. It's effectively the first half of the paragraph.
So what are you saying about that?
Well, what we say is that it's unfortunate that the judge has added to the reasons in this way. And I don't dispute that a judge may add to extempore reasons or correct the transcript, but when doing so, the judge must act judicially and should not take into account factors such as, for example, an appeal by one of the parties on that issue, or seek to remedy any inadequacy in the initial reasoning. And that, in my submission, is what appears to have happened.
So you're saying that the judge did not act judicially, as you said he must, and you're saying that he has had regard to the appeal and has added to his reasons in light of that, in a way that is improper. Is that what you're saying?
Of course, I don't know.
Well, it's your case, Mr. Solomon.
It's my case.
I need to know what you are saying.
There is. It appears that is the position, my lady.
Well, what is your submission? Are you saying the judge has acted improperly?
My submission is this: that the a judge should be hesitant to add to reasoning, and from an extempore judgment, and the party should know the position from the extempore judgment.
So that's what a judge should do. And now I'm asking you for your submission so I can write it down. What you say this judge has done.
My submission is that he has added to the reasoning in a way that does not assist the parties and was not his reasoning in the extempore judgment. But in any event...
And is that improper? Very often judges do. It was an extempore judgment given at the end of a long hearing where he had to deal with a whole host of other matters. It wasn't probably the focus of his attention because there were so many other matters. But he had those reasons in mind and he has articulated them more clearly. Now,
well,
do you accept that that's a possibility, or are you saying he has behaved improperly?
Of course I accept that's a possibility, my lady. I do, however, note that 2 points. Those aren't the reasons he gave orally.
Those are
not. So from the third line down on page 275 are not the reasons he gave orally.
Well, he didn't spell them out, but they may well have been in his mind. They were obvious reasons, frankly.
Well, I'll address your ladyship on them, because in my submission they are
all right,
wrong.
But he may have had them in his mind.
I accept that.
And if that is right, it can't possibly be improper for him to articulate them when he comes to approve his judgment, can it?
If he had them in mind, I accept it's not improper, my lady. What I do know, however, is what the judge said when refusing permission to appeal. And the written reasons for refusing permission to appeal can be found at page 93 of the core bundle. And at 94, paragraph 1 is the reasons for refusing the claimant's application for permission. And paragraph 2 is the reasons for refusing my application for permission. He said, I made the order principally, according to D1's evidence, in his first year of working, he wouldn't be engaged in any trading so that a speedy trial could resolve whether the covenant was enforceable before then. The application for permission, and that's the reason he gave orally, my lady.
Yeah.
The application for permission to appeal was that in light of C's delay and other factors, it was wrong for it to be a speedy trial. There was no real prospect showing I'd erred in making a discretionary decision. So he repeats in writing the reason he gave orally, my lady. The order that was made after the hearing was agreed by the parties pursuant to the judgment, and that can be found at page 54 of the bundle. Core bundle. And you'll see that the application, that's the application for interim relief, is dismissed. And there's a speedy trial of the claim. That's a unitary speedy trial on all of the claimant's claims against both defendants. And then a series of directions for that speedy trial. Defences were served by the 9th of May. There was no reply. On disclosure, the second defendant didn't comply initially with the order for disclosure because the claimant had indicated it was no longer going to pursue the claim against the second defendant. We applied for a stay of directions, but that was refused by the judge, Mr. Ford AC, when it came before him again. Disclosure has now been completed. As you've heard, the claimant is dissatisfied with the disclosure from both parties and made a specific disclosure application against both parties. Notwithstanding that it's indicated against my client, it's not going to proceed at all against it in the speedy trial. There is as yet no agreed trial bundle. That should have been agreed by the 5th of June. That's paragraph 8 of the order. And then your Ladyships will see that witness statements of fact are due by the 19th of June, and the speedy trial has a trial time estimate of 5 days. A draft timetable has been provided by the claimant, and that is at supplemental bundle page 258.
Do we need to look at it? Do we need to look at it?
Well, if I can show it briefly, just to make one point.
Yep.
(258 to 259).
Yep.
Your Ladyships will see that this is the claimant's time estimate for the speedy trial which it sought and obtained. Its trial estimate before the judge was 3 days. It was ordered to be a 5-day trial. You'll see there's no time for judgment in that speedy trial, nor is there any provision at all for the second defendant, who is a party to this trial. It's not mentioned, there's no submissions, no evidence or anything from the second defendant. So on the claimant's trial time estimate, even leaving my client out, which is wrong, because it's got a claim against it, it can't be done within 5 days. I've told your Ladyship there's an outstanding application by the claimant for an amendment. That's coming on next week, on the 13th of June, and the claimant has now sought to have that heard. That's a 2-hour application hearing with its 2 further applications for split trial and specific disclosure. There are significant elements of the trial timetable still to be done. There is a huge amount of work to be done, and it would be the parties are under huge stress trying to deal with that and all the claimant's applications, and there's a huge amount of costs to be incurred as well. So
Well, they're costs that would have had to be incurred anyway.
Well, maybe or maybe not. But if the speedy trial if the order for a speedy trial is set aside, my lady, at the moment, the only claim that the claimant is bringing is for injunctive relief.
Yeah.
And it's inconceivable that it would bring a claim for injunctive relief if there's no speedy trial. So that claim would go. And no one knows what amendments will be allowed. But the vast majority of trials don't happen. The vast majority of trials, as your Ladyship knows, settle. But the problem with speedy trials is it forces the party to incur costs very quickly, and it often forces the parties to litigate. So these aren't costs that would inevitably be incurred. And in my submission, if your Ladyships overturn the order for a speedy trial, it's inconceivable that the trial as currently listed, for the issues listed, would ever take place. The last point is that the claimant the first defendant started work with the second defendant on the 18th of May. So he's been employed for a few weeks. Returning to my submissions, my lady. I fully accept that an appellate court will only interfere with case management decision in very limited circumstances. And I underline and accept the Jump's position that BPP Holdings sets out the right test, that an appellate court shouldn't interfere with case management decisions unless the decision is unjustifiable because irrelevant matters are taken into account, or relevant matters are not taken into account, or it was plainly wrong.
Yeah.
And indeed, that is the approach that this court took in Petter,
Yeah.
which is at tab 15 of the authorities bundle, No, it's not. It's tab 24 of the authorities bundle. It's paragraph 15 I was wanting to refer to, not tab 15. Paragraph 15 at page 403 of the authorities bundle, which was an appeal against a speedy trial. My learned friend was for the appellant. And the court set out that it will only interfere with the judge's exercise discretion in very limited circumstances where the judge has not merely preferred an imperfect solution different from an alternative imperfect solution which the court of appeal might have adopted that exceeded the generous ambit within which reasonable disagreement is possible. So I fully accept all the way those different tests are called. But in my submission, this decision is plainly wrong. The principles are in Petter, are set out in my skeleton argument and are at paragraphs 10 to 14 of the judgment. Unless your ladyships want me to, I'm not going to read them. There is a difference, however, between a normal case management decision, like for example, whether disclosure should be ordered on the 1st or the 31st of a month, and an order for a speedy trial. And that is primarily because it adversely affects other court users, as all the courts, all cases consistently underline. And because it puts huge pressure on the parties to a speedy trial. That is, those effects are always inevitable in any speedy trial. And so it is a discretion that is, unlike other judicial discretions, other case management discretions, and it is, in my submission, easier for a court to interfere with that. And that's the
So I
reason.
thought you accepted the high hurdle, and now you're saying you don't accept it,
No, I
because
do
this is a
accept-
special sort of case management decision.
It does have specific. I accept that's the test, my lord.
Right.
But the points made in Petter are the points that a judge has to take into account, and that underlines the factors that apply to this sort of case management decision.
I see.
Like, for example,
Yeah, I see what you're saying.
where at paragraph 12,
Yep.
whether the applicants have shown good reason and burdens on the applicants, whether expedition would interfere with the good administration of justice,
Yep.
and whether expedition would cause prejudice to the party, whether there are other special factors. So
Those are the factors in deciding whether to order a speedy trial.
yes,
Yeah.
and those sorts of factors are not present in run-of-the-mill case management decisions that a judge makes.
So what?
Well, okay.
We're dealing with this.
We're dealing with
Right,
this.
okay.
It's a different sort of case
But
management.
so what? That's the bit I don't understand. I understand that the discretion to order a speedy trial must be exercised judicially, and that there are factors that have been identified in the authorities that are likely to be relevant. They may not be relevant in every case, but they're likely to be. And I understand that you have an argument that the decision to order a speedy trial is plainly wrong in this case. But so what if this is a different sort of case management decision to another? Unless you're saying the high hurdle doesn't apply to this
No,
sort of
I'm not
case
saying
management decision.
What I am, of course I'm not, because that is what the case has said.
That's
Um,
fine.
but
Well, then
what
I
I
don't
am
think
saying
it
is
matters that it's a
the
different
im-
sort of case management decision.
It impacts on for example, on the judge's explanation for ordering a speedy trial. It might well be, my lady, that deciding on the 15th or the 16th of the month to order disclosure needs much less explanation than deciding whether to order a speedy trial.
Well, this isn't a reasons challenge.
No,
You're
it's
challenging
not.
the decision as plainly wrong.
Yes.
So let's look at whether it's plainly wrong.
Okay. A couple of preliminary points before I get to my grounds. As a matter of fact, undisputable fact, the claimant, respondent, now, in its skeleton argument, did not address speedy trial at all in its skeleton argument before Mr. Ford makes it for the interim hearing. Nor did it make any submissions on speedy trial, nor was the question of delay addressed at all in its evidence. And the burden is on the claimant to show reason for the speedy trial. Its case now, apparently, in the skeleton argument that is put before the Court of Appeal, is that commercial certainty and the need to limit uncompensatable damage are reasons for the speedy trial. But these weren't reasons it advanced below. They don't form part of the judge's reasoning, and there's been no respondent's notice on those points.
Why would you need a respondent's notice? Your challenge is to an order. Your challenge isn't to the reasons. Why would they need a respondent's notice?
It's not suggested that there are different reasons for upholding the speedy trial by judge. That's all I'm saying.
Oh, okay, all right.
So ground one, my lady, is that the defendant's delay, which the judge found was stark and unexplained, disentitled it to an order for a speedy trial. An order for a speedy trial is an exercise of discretion, just like an order for enforcing interim relief. So it's a similar exercise of discretion. And on the latter, the judge concluded that the unexplained and stark delay disentitled the claimant to relief. But on the question of speedy trial, he did not reach the same conclusion. And we say fundamentally, the test of real, objectively viewed urgency, which is what all the cases underline, and what was agreed by the claimant was the right test before the judge. Mr. Laing for Jump accepted in reply that the law as I'd set out was correct.
So the judge had the law in mind, we know that. He had Petter cited to him.
The judge had it set out to him.
Yeah.
And what he also had was the fact before him that the respondents to the application, my client and Mr. Couture, had set out in correspondence that there was unexplained delay.
Yep.
They had dealt with that point in their evidence, and the claimant had failed to deal with it, either in its initial or reply evidence.
And the judge recognised that?
In respect of the...
Well, he recognised there was unexplained delay.
Yes.
But he didn't think it disentitled the claimant from a speedy trial order.
Yes.
No doubt, because if the claimant was successful at the speedy trial, there would be an injunction to run coterminously with the covenants to expire at the end of the covenant period.
Yes.
And that is a paradigm example of a case for a speedy trial, isn't it?
No.
Delay wouldn't disentitle them from getting an injunction at the trial.
No.
So
it may do. It may do because you've got to assess status quo.
Not at the trial. At the trial.
Well, at the trial, yes, I accept that delay at the trial was...
So the delay becomes irrelevant.
Yes, I accept that.
Right. Yep.
The judge, but the the ball point is that given the claimant's unexplained delay, the judge couldn't have reached the conclusion that there was real, objectively viewed urgency. And the claimant accepted in the hearing, it's recorded by the judge, that it could have commenced proceedings earlier, and that would have removed entirely the need for any interim relief, and it could have commenced arbitral proceedings, and perhaps not even needed a speedy trial if the parties had contracted for arbitral proceedings to have determined before the commencement of employment. And that
your ground of appeal is that delay rendered it inconsistent for a speedy trial to be ordered,
Well,
but
on
you've
the-
just accepted that at the trial, delay would have been irrelevant. So I just don't understand this point, Mr. Simler. I'm sorry,
My submission
maybe
is
I'm
this.
being
My
obtuse.
submission is this, that there cannot be real objectively viewed urgency when the urgency is created by the claimant's own delay. And had it been urgent, the claimant would have acted sooner and commenced either proceedings in court or before an arbitration in order to entirely avoid this situation that it's created. So in that context, it's impossible in my submission for the judge to have concluded there was real objectively viewed urgency.
Okay.
So that's ground one.
Yeah.
my lady. I'm going to deal with grounds 2 and 3 together. The judge applied the wrong test,
Yeah.
and it wasn't justified on any evidential basis.
Yeah.
The reasons that he gave, and the primary reason, even in the approved transcript, was that on the first defendant's evidence he wouldn't be competing for the first year, not that there was real objectively viewed urgency. As to that, there are 4 short points in my that's not the right test. The test is not whether there could be a trial in the period where on the first defendant's evidence he's not competing. The test is whether there is real objectively viewed urgency in this case.
Sorry to interrupt, Mr. Solomon, but why isn't the mere fact that the clause is time limited and will expire on a particular date reason for urgency and holding the trial before the clause's validity expires?
Urgency only arises, my lady, because the claimant delayed. So it sat on its hands.
No, I've got that point.
But
This is
urgency
a separate
isn't
point. This is a separate point. Why isn't the mere fact that the clause will expire quite soon a reason for holding a speedy trial before the clause expires?
In the normal course of events, if there is a limited period of restriction, that is a reason to have a speedy trial.
So in the normal case, it would be a reason.
In a normal case, it would be.
So what makes it abnormal?
This case is abnormal for a variety of reasons. First, there was a extended garden leave period in which the claimant could.
Well, that's nothing to do with the speed. That's nothing to do with this point. That's to do with, is the clause enforceable?
No, my lady. If the claimant had acted during the extended garden leave period, when it knew that the first defendant was intending to compete, it says unlawfully, then it would have removed the need entirely for any speedy trial.
Well, no. It may well have got the speedy trial much earlier. There would have had to be a speedy trial,
Well, there could have,
but it would have been a much earlier speedy
or there could
trial.
have been an arbitration, and it could have been a much more leisurely speedy trial. If it had acted in July 2022, or even November 2022, it had to get the trial on before the end of March 2023. So much more leisurely than the period we're now in. And only, if it's an arbitration, only as against the first defendant, not against the second defendant.
So you're back to delay, really. It
Yes.
boils down to ground one. Is there a separate
Ground one, and
argument other than ground one?
Point 2 is that in a normal application for interim injunctive relief in which a speedy trial is granted, it is granted in addition to interim relief being granted. And we, for our part, have not been able to find a single case where interim relief was refused, especially on grounds of delay, and a speedy trial granted.
Well, but that may well be because the likelihood is that that the covenant was coming to an end much more quickly. This covenant still has nearly 10 months to run. In many cases, the covenant period is much shorter, and if you don't get the injunction, the speedy trial isn't really going to fix it unless you have it very quickly, which is very often impractical. But I can't see why the mere fact that you don't get the injunctive relief should disentitle you from a speedy trial, given that at the speedy trial you will get your injunction if you're right.
The third point is that on the claimant's case, the irreparable damage has happened. And so on the claimant's case, there is no advantage to a speedy trial. That is its repeated evidence.
This goes back to a question I asked you earlier, Mr. Solomon. Does the claimant anywhere say, suffer immediate irreparable damage if he starts work for our competitor, but we're not ever going to suffer any more damage if he continues to work for our competitor?
It hasn't said the latter point.
No. So I mean, the first point doesn't exclude the second.
Well, immediate, unquantifiable and irreparable damage, my submission includes the second point.
What that means, they won't suffer any more.
So by implication, they're saying we'll suffer immediate irreparable damage, and we won't suffer any further damage if he continues to work for our competitor.
It's unknowable.
Is that your submission?
If it's irreparable, I think what they say is we don't know what the extent of the damage will be. We can't know.
Yes.
Damages are inadequate remedy for us. So we can't possibly know what the position is. And there is, I accept there's no evidence to that effect, but
no, all right.
But one would never have that sort of evidence. It has pinned its colours to the mast of saying you can't start work for Verition because if you do, that's the end.
Because they were applying for an interim injunction.
The consistent metaphors it has used have been all or nothing metaphors. The cat cannot be let out of the bag. The bell cannot be unrung. These are binary positions.
It's a non sequitur to use those propositions as the basis for a further proposition that they won't suffer any more damage if he continues to work for the competitor.
Well, I accept that evidence isn't before the court. They haven't put in that evidence.
No, but I mean, it's
and one would have imagined that they should, because the burden's on them to demonstrate why a speedy trial should be permitted. But that they haven't. And turning to the judge's own reasons in the extended reasons, approved reasons.
Yeah.
What the judge says at page 275 of the supplemental bundle is that picking it up from the third line down, which is where
the objective reason. From the objective reason.
Exactly. The objective reason for expedition is to hear the claim promptly, early in the lifetime of the covenant. Pausing there for a moment, with respect, that's a tautology. The objective reason for a speedy trial is to hear the claim promptly, is saying the same thing twice. But he then goes on, and before much direct competition has taken place, see Petter. With respect to the judge, that is not what Petter says. It does not say you should have expedition in order to stop much direct competition. Normally, as I've said, speedy trials are in the context of claims where interim relief has been granted, which stops any loss. And there's no mention...
Well, which stops direct competition.
Which stops direct competition.
Well, and that's... So the judge is saying this is an analogous situation. It's not analogous because I've granted the interim injunction. It's analogous because on the claimants, on Mr. Couture's case, He's not actually going to start competing immediately.
Yes.
So what's the difference?
Because PETA does not say that you have a speedy trial in order to permit a little bit of competition, but to stop a greater amount. That's not the reason for expedition ever. These things are much more binary in my submission.
Which things are? Which things are much more binary?
The grant of injunctive relief, the
Yes.
discretion to grant injunctive
Yes.
relief, and the discretion to order speedy trials.
Yes.
And what the judge has done is say, on the defendant's evidence, there is no competition in the first year, but I'm going to order a speedy trial before much direct competition has taken place.
Yeah.
And there were two competing evidential positions before him.
Yes.
The defendants, which was there'll be no competition
Yeah.
for the first year, and the claimants,
There
which
will.
will be inevitable immediate competition.
Yeah.
And what the judge has done is say, I'm following PETA, which is that you should have a speedy trial to prevent much direct competition taking place.
Right. So if it hadn't referred to PETA, you couldn't criticise that sentence, could you?
Well,
It's a perfectly sensible
my-
point to make.
with respect, it's not a sensible point to make. It's
Okay, well,
wrong.
tell us
it
why.
does not apply PETA. PETA says nothing about having speedy trials to prevent greater amounts of direct competition. It talks about real objective urgency.
But my lady put to you a little while ago that, and I think you accepted in the normal case, the point, that the mere fact that the clause is time limited and will expire at a point not too far off in the future is a reason for concluding that there is objectively justified urgency that would justify a trial before the clause expired. And you said, yes, you accept in a normal case that is a good reason.
In a normal
Well,
case, but I
the
gave
judge
reasons
here has concluded that that is a good reason.
I accept.
And
I
I'm
gave-
asking you, why isn't it a good reason? Why is he plainly wrong?
I gave reasons why this isn't a normal case in answer to that question. But also, he's plainly wrong in this case because what he has said applying PETA does not apply PETA, and PETA says nothing.
But leaving aside PETA, if he hadn't, let's pretend he didn't refer to PETA and the sentence stood on its own. Okay? Why
Yes.
isn't that a good objective reason?
Well, with respect, the fundamental point that the claimant has delayed is outweighs the.
So we're back to ground one,
we are-
delay. Well, does this
in
appeal
essence-
boil down to ground one? You have no additional points to make. Is that what it boils down to? Because each time we ask you, we're now on grounds 2 and 3, which aren't delay. Delay was ground 1. Is
Right,
there
well,
something separate you want to say about grounds 2 and 3?
Yes.
Mr. Solomon?
There is.
Okay, well, say it, please.
Thank you. The next point the judge makes is that there's no prejudice to either defendant has been suggested.
Right.
And that is wrong. Mr. Visecki, in his witness statement, set out prejudice at length. His witness statement starts in the supplemental bundle at page 31, and you can see it at page 34, where Mr. Visecki, 34 paragraphs 12 and onwards, dealt with prejudice. And he says in terms, he talks about what the steps that have been taken because of Jump's delay.
So that's Jump's delay, but we're talking about prejudice in the order for a speedy trial here, not prejudice in delay, not prejudice in an injunction. We're talking about a speedy trial. So show us where the evidence is that having a speedy trial would cause either defendant delay.
Prejudice.
Prejudice, I'm so sorry.
It's my fault. It's my fault.
It's
saying
my
delay.
fault.
No, it's my fault.
Go on.
I forced it onto you, my lady. I accept the evidence before him was aimed at prejudice because of the way in which Jump has conducted itself. But the evidence was that had they acted sooner, the defendants would not have taken on this team and would not have incurred these costs, and the costs of the team are ongoing. So if there is a speedy trial and the claimant is successful at the end of that, all those costs will have been undermined. But also, in the skeleton argument that we relied upon in front of the judge, we referred the judge...
Well, before you move to that, you started this submission by saying where the judge says there's no evidence of prejudice to either defendant, or it's not been suggested there is prejudice to either defendant in an order for a speedy trial by inference. You said that was wrong. But are you now accepting there was no evidence or no suggestion? There was suggestion of other sorts of prejudice, but not in relation to a speedy trial.
I made the point in my skeleton argument, my lady, that expedition causes prejudice to the other parties.
You just made that general assertion.
I made it as a submission, yes, relying on the case law.
So that's the judge was entitled to say no prejudice to either defendant has been suggested, because expedition causes prejudice. Well, what does that mean?
That's what that's one of the four factors identified by Lord Justice Neuberger in Gore and Geox.
But where there wasn't any evidence from either defendant to say they were prejudiced or would be prejudiced by an order for expedition. Is that fair?
There was no evidence directed specifically to the position of interim relief not being granted but a speedy trial being granted. There was evidence on the prejudice, the ongoing prejudice by the way in which the claimants have conducted their case.
Yeah, okay.
And the fact is, if the covenant's upheld after a speedy trial, that's just tough. I mean, I imagine your clients took legal advice on this point before they incurred the expense.
Yeah, they did. And we've waived privilege on that, and the legal advice was that it was unenforceable, which is
you may turn out to be right about that.
We may do, and that's part of the reason that I expect. In fact, that's completely the reason why the judge said the inducement claim against my client was wrong, and I will rely on that in my submission that the judge was wrong in finding that the length was seriously arguable. But the final point on this, if I may, is that the submission made to the judge by then counsel for Jump was that, and it's repeating this skeleton argument, that there are almost always speedy trials ordered in these cases. We objected to that, saying that's wrong, and that it's very different when interim relief isn't granted. And your ladyship would have seen the comment by Lord Justice Bean.
Well, I thought we were looking at Mr. Ford's decision, not what Mr. Laddie said about it or what Lord Justice Bean said about it. Mr. Ford didn't say I'm going to order a speedy trial because in nearly every case of this kind there is a speedy trial.
No, he didn't.
So what's the error that you're relying on?
Well, that was the submission made to him, and that might have been part of his thinking when he came to that conclusion.
Well, what's your basis for it? You're
just
guessing.
I accept he doesn't say that in his reasoning.
Well, that's just pure speculation, Mr. Solomon. Okay.
My last point, my lady, is ground 4.
Yeah.
Has the judge correctly determined that there was no serious issue to be tried?
Yeah.
He would never have ordered a speedy trial. And there are two bases for saying this. First, that the covenant is a very strange covenant with a unilateral ability to determine the length of the covenant granted to the employer after termination.
Yeah.
And secondly, the time of the covenant is excessive.
On its own or added to the garden leave?
Added to the garden leave. So the judge sets out the relevant clauses in the judgment. That might be the easiest place for your lordship to pick it up.
Yeah.
Supplemental bundle 267.
Yep.
Page 267. The non-compete clause. For your ladyship's note, that's clause 19.1 at page 148 of the core bundle. And that's in order to protect confidential information and so on, you agree to refrain at all times from directly or indirectly engaging in any commercial activity during your employment and during any notice period, garden leave, and the non-compete period. And the non-compete period is defined at clause 1.1 as meaning 0 to 12-month period after the termination date as elected by the company within 20 business days following notice of termination. The non-compete period should commence at the conclusion of any applicable garden leave or notice.
Yeah.
My submission below, which wasn't gainsaid by the council team for Jump, was that this is the first time that a covenant like this has been considered in any court in England and Wales. And that remains my submission, and it still isn't gainsaid by Jump.
Okay, so it's a very unusual clause.
It's a very unusual clause, in fact unique in my submission before the courts of England and Wales. And the submission I've made below was that it was unique worldwide, but my learned friend has indeed found a Scottish case,
yeah.
Albeit, as I've said in my note.
Anyway, that doesn't really matter, whether it's unique or been before the courts before. The question is it frivolous and vexatious to argue that it's enforceable?
Yeah.
I mean, it's a pretty low.
Yes.
So is there a serious issue to be tried as to the enforceability of this?
Yes.
The judge said he thought it was, you probably had the better argument, but he couldn't say there wasn't a serious issue to be tried. Is that
yes. He said, paragraph 29, page 271.
Yeah.
The conclusion, the last line. Where you can say, he said, I can see maybe a degree of an unacceptable inter rorum effect. Resigning employee won't know the period of restriction at the point when he or she resigns until he receives the notice. But in these murky and uncharted waters, don't consider, I can say, there's no serious issue to be tried. The submission that was made before the judge was that this is a crisp point of law that should be determined by the judge.
But these cases are fact specific, aren't they? You need to know about the industry, you need to know more about what sort of confidential information and how the longevity of that information, how it might be used, why for the claimant they regard it as legitimate to have a period of up to 12 months after a garden leave
Yes.
period.
All of those points
specific.
All of those points are fact-specific points,
Yeah.
but not the question of whether a unilateral power to determine the length of a covenant can be exercised by an employer after notice of termination. That is a specific, crisp point of law that can be determined discreetly. My submission is, I don't need to take your ladyship to the cases. Your ladyship has the point that the more unusual the covenant, the greater the likelihood is that it's unenforceable, and the flip side applies. And your ladyship found in the case of Croesus that if something is industry standard, it's more grounds for saying it's reasonable.
So you say it was plainly wrong for the judge to take the view. Well,
Yes.
this isn't.
No,
This isn't. This isn't. We aren't. It was wrong for the judge to take the view
correct.
that this was not a point that he felt able to determine then and there, and nor could he say there was no serious
Yes,
issue to be tried.
correct. That's right. And had he determined that in my favour, he would inevitably have refused interim relief.
Which he did anyway.
Refused to order a speedy trial
Right.
because there was
Well, there wouldn't have been anything to
No,
try.
Exactly.
But would there still have been something to be tried?
no.
Not at all.
No.
As you say,
The-
the mere fact that there was a 0 to 12 month period was something that he could try and avoid, irrespective of the factual matrix
Yes.
surrounding it.
Yes.
Okay.
It's such an objectionable point that it cannot ever be upheld. The first point I make, and I rely on 2 cases to make good this point. The first case I refer to is the case of PAT systems and Laing, and that is behind tab 14 of the authorities bundle, decision of Mr. Justice Under, who he then was. And this, because there are no cases on point, I'm proceeding by way of analogy. This is a case in which there was a covenant which was...
Is the point you're making by reference to this case that the time for ascertaining the reasonableness of the clause is at the date of commencement of the employment?
Exactly.
Well, that's well established. I don't think you need authority for that.
And that an employee
But what would be said in relation to this clause is, as at the date at which Mr. Couture signs the contract of employment, he knows that there will be up to and the maximum of 12 months following
Yes.
a period of garden leave. That's what he's signing up to.
Yes.
What you have to test the reasonableness of that. The employer may reduce that at its discretion, but you test the reasonableness of 12 months on top of garden leave.
What he knows is that there is a restricted period of anything from 0 to 12. He doesn't know how much it will be.
But he knows the maximum will be 12.
And he knows the maximum will be 12, and he knows the minimum will be 0, but he doesn't know what it will be.
And he knows he'll know within 20 days of giving notice.
Exactly. So at the time he resigns, he doesn't know the...
Well, he knows that the top whack it'll be 12.
He knows the outside
Yeah.
threat.
So the question is is it fair to and reasonable to have a discretion? But B, he knows what the top whack is, and so is that reasonable?
Yes. And in PAT systems, it was held that an employee was entitled to know their position in respect of a covenant. And so although a covenant may become enforceable because someone's promoted, if it was unenforceable at the beginning, it wouldn't ever be enforceable. It's void ab initio.
Yeah. So he is well advised to proceed on the basis that it will be 12, but if he's lucky, it may be less.
That may be a practical solution, my lady.
Well,
but
it's the way the clause is framed, isn't it?
the construction of the clause is not that there's a presumption of 12 months. The construction is that there is no presumption, and it could be anything from 0 to 12.
Okay.
And one might be entitled to proceed on the basis that if you're held to your garden leave period of 12 months, then it won't be enforced. But the reason it's there is because it's effectively a set-off against garden leave. That might be a legitimate view to take. But
Well, some clauses are phrased in that way. This one isn't.
No, it isn't. There is no
it's not
set-off for garden
legitimate
leave.
to take that view.
And so here, he doesn't know what it will be. He knows the maximum and he knows the minimum, but he doesn't know what it will be. And we say that's wrong in principle.
Okay.
And the second case that we proceed by analogy with is the humming flowers case, where cascading covenants were held to be unenforceable. And the point
I'm
is
not
that
familiar with humming. What is it? Humming flower.
humming flowers.
Where's that?
It's tab 20. It's a long case in the Singapore High Court, and it was referred to with approval by the Supreme Court in Egon Zender, which described the reasoning as magisterial, I think. Wilson, with whom the rest of the Supreme Court agreed, said Humming Flower is a magisterial survey of the standing principle in Singapore, albeit conducted at first instance, concluded that its application, i.e. blue penciling, application of blue penciling, there was subject to 3 criteria proved in Beckett.
So which paragraph do you want us to look at in Humming Flower?
It's the final paragraph on the last page, which is page 341.
Right. 197.
Paragraph 197.
Yep.
It would sort of be easier to understand this reasoning, Mr. Solomon, please, if you could share us the language of the covenant.
Yes. The covenant is at page 300. Paragraph 15 set out at clause 13 there. But if I can, it's not a particularly easy covenant to understand.
Well, we just need to understand what the cascading bit of it is.
Yeah.
If I can explain it.
Can you just explain it by reference to the wording? Is it the second part or the first part or both?
It's the second and the third part. So the beginning bit is a non-compete, and then there are two different types of non-solicit. So the non-solicit would be included in the non-compete.
Is it cascading in terms of time or cascading in terms of coverage?
Scope, exactly.
Scope.
So because a non-compete is wider, it would necessarily include a non-solicit. And the covenant's very...
So it's nothing like the one in our case?
Nothing like the one in our case. I'm proceeding by way of analogy because there is no case on point. What the court in Singapore said in cascading covenants is that they are unenforceable. They had an interorum effect because the employee doesn't know the position in which he stands, which is exactly the point your ladyship made to me, that the employee will know the greatest scope, he or she will know that there is a non-compete covenant.
But I guess with this sort of a clause, you don't know the scope of the covenant itself.
Yes.
Time is a much clearer concept. The employee knows it'll either be 12 months or something less than 12 months on top of his garden leave.
But you could have
with scope. It's much more nuanced, isn't it?
With respect, exactly the same thinking, exactly the same theory would apply to a cascading covenant in time. So you could have a covenant which says you may not compete for A, 12 months, B, 6 months, or C, 3 months. And A includes B and C necessarily. But when the employee enters into it, he doesn't know which one applies. He knows that the outside is 12 months, the minimum is 3 months, but he doesn't know which one will apply. And it has an interorum effect on the employee. In a cascading covenant, the employer is hoping that the court will intervene and blue pencil the bits that are unenforceable, and the courts have instantly refused to do that. And there's no example of the courts in this country ever having grappled with this point, but in my submission they would refuse to do that. And this is much more employer-friendly than a cascading covenant, because it's not being left up to the court to determine, it's entirely up to the employer. And there can be no blue penciling. The covenant is either enforceable or not enforceable entirely in and of itself. And your ladyship may have read the note I put in about the cases relied upon by my learned friend, and they draw the distinction between unitary clauses like the one we have in our case, and different other clauses like the example I've just given where different bits can be blue penciled, and unitary clauses are unenforceable, and this is exactly what we have here. So it is the most egregious example, we say, of a sort of covenant which gives the employer all the power, does not allow the employee to know what the extent of the covenant is at the date he enters into the contract, and cannot be justified, we say, when the contract is entered into, because in order to justify it, you have to construe the clause properly, and construing the clause means that the temporal period is anything from 0 to 12 months. So in order to justify it, the employer will have to justify not just 12 months being the outside time, but all the periods in between.
But if 12 months is justified, doesn't it inevitably mean that a lesser period is justified? That's the problem with your submission, isn't it? Scope is much more nuanced, and you might be able to justify non-solicitor for some and non-compete for others, and it may well be a difficult exercise. But if you can justify 12 months, surely that means you've justified 6. I just don't understand why not.
If the position, I'll answer it like this, Molly. If the position is that the covenant in effect means it's a 12-month covenant, well, the first question is, what does the covenant mean? That's the first task for the court. Yeah. And the covenant does not mean it's a 12-month clause. It means it's anything from 0 to 12. There's no presumption that it's 12 months. And so in order to justify it, my submission is you've got to be able to justify every period within that.
But if you can justify 12 months, I mean, forget presumptions. If the employer can justify 12 months, isn't it inevitable that the employer will have justified 6 and 3 and 1?
The problem there is that that's not what the covenant says.
Okay.
So if what your ladyship has done with that reading in discussion with me is to read the clause as if it is a 12-month covenant. And that's what the claimant accepted would be its position at trial, that we have to justify a 12-month covenant. But that is not what the covenant says. It's not a 12-month covenant.
Well, it's an up to 12-month covenant, and
Yes.
therefore they must justify 12 months.
My submission remains that the employer's got to pick a figure. You can't just say anything from 0 to 12.
Okay. So, yeah. So, I mean, your submission is straightforward. The mere fact that it says 0 to 12 rather than 12 means it is unenforceable, and there can be no possible argument to the contrary.
Yes.
What if the clause had been slightly different and had said the non-compete period is 12 months, but the employer may, at its election within 20 business days following notice of termination, decide to impose a lesser period? Would there be anything wrong with that?
No, there would be nothing wrong with that.
Right.
That's not what the clause says.
All right.
So the court...
Can I just get a note of that, please?
So there are... Sorry, Melanie.
Just sorry,
I'll wait for you.
I'm rather slow at writing. I'm
No,
afraid.
it's my fault.
Thank you.
The court must construe what a covenant means, in fact, and may not rewrite it to make it more reasonable. And so a different covenant, if it had just said there is a 12-month restraint period, I wouldn't have had this ability to attack it in the way I have.
So if it had just said 12 months, you would have accepted that the judge was entitled to say there was a serious issue.
Subject to my point on time. Under this head, under the uncertainty head, if you will, yes. Every contractual right contains within it the ability for the party with that right not to enforce its strict rights.
Yeah.
So every covenant, for every time an employer has a covenant, they can say, I'm entitled to 12 months, but I only want to enforce 6 months.
Yeah.
And that's what a court will enforce.
Yeah.
Because if it's not justifiable after 6 months, it won't be enforced. But this isn't that type of covenant. So the example Lady Justice Laing gave to me is a different type of covenant that would apply in every other case. But so it's unenforceable on its own terms, and it cuts across the reasoning in Humming Flower, which was held to be magisterial in the Supreme Court.
Or was the Supreme Court endorsing every
No.
syllable of Humming Flower, or simply endorsing its analysis of the blue pencil rule?
The latter, but there was discussion about how blue penciling worked in cascading covenants in oral.
But we're not in a blue penciling situation.
No, we're not.
So how does Humming Flower even begin to help us?
Well, because with a cascading covenant, there is a possibility that you can blue pencil in order to save it. But with this sort of covenant, there isn't even that possibility.
Yes. This
So
isn't.
it's even more extreme than a cascading covenant, and cascading covenants are unenforceable.
Okay. I mean, you can name it a cascading covenant. I don't really know what that means. It seems to me it's a covenant which is 12 months unless the employer exercises its discretion to reduce the period to somewhere between 0 and 12 within the 20 days that they're entitled to. But anyway.
That, with respect, that isn't what the covenant says, my lady.
What's the difference in substance between the formulation I put to you and the drafting of clause 19.1?
It's the point I made to your ladyship, that first an employee will know where he or she stands. If the clause says it's a 12-month covenant, but we can reduce if we want to, the employee will know where he or she stands.
That's what the employee must take from the non-compete period, mustn't they? If you read that, don't you inevitably conclude that it's going to be 12 months unless the employer says it's something less than 12 months?
No.
Why not?
Because the natural reading of the clause is that the only reading of the clause is that the covenant means 0 to 12 months. That's it.
But it's up to the employer to decide if it's going to be less than 12 months.
Or more than 0. But there's no presumption that it's 12 months. It could be anything.
Forget presumption. I don't know where presumption comes into it. The top whack is 12 months, unless the employer says to you it's going to be less.
That is not how it works with respect.
But why?
The employer will elect. It's 12 months unless you're told it's less. The employer will elect the period.
But the employer is constrained by 12 months. So the employer cannot impose any more than 12 months.
Right.
So the maximum that can be imposed is 12 months.
Yeah.
So it's going to be 12 months unless the employer chooses a lesser period. It can never be more than 12 months.
It's going to be a period between 0 and 12 months.
Yes. 12 months is the most it can be, so it's going to be 12 months or less.
Yes.
Why is that different from the point put to you by my Lady Justice Laing?
There is a fundamental difference between telling an employee there is a restricted period of somewhere between 0 and 12 and telling an employee that there is a restricted period of 12, but as with all contractual rights, we've got an ability not to enforce it strictly. And in the latter, the employee will know where they stand, because that's true of every covenant. And in the former, the employee won't. And by analogy, that's why an employee does not know where they stand with what has been called cascading covenants, because with a cascading covenant, if you have 3 time periods or 2 time periods, 6 months and 12 months, the employee will not know which one is going to be enforced until it's determined.
Okay, so that's your point on the first point, the clause, the unilateral ability to change the length.
Yeah.
Okay. And
on timing, I'm going to deal with this quickly, my lady. I accept that it's normally the case that questions of temporal scope are matters for evidence, unless they are obviously outside what is reasonable. If, for example, you have a covenant that is for 10 years, you can't compete for 10 years, that's obviously unenforceable. And we say that this covenant falls the wrong side of the line. The only evidence that the claimant put before the court was in respect of this extent of covenant being standard was for an LLP member, not an employee. There was no evidence before the court that other employees had a year of garden leave followed by a year of restraint. And as I've indicated to your ladyship, we took legal advice, we got legal advice, and we've waived privilege in respect of that. And the bullish, when we say correct legal advice, my submission came back from Sidley Austin was that it's probably unenforceable because of the...
Probably.
Probably.
Well, so what? The judge said, I can't, this is murky waters, I can't say there's no serious issue to be tried. It sounds like he was bang on point in terms of the legal advice that you got. Probably. You can't say he's wrong to say that there's a serious issue in those circumstances. I mean, leaving aside the relevance of the legal advice at all to the point. But
I accept that. I accept it's not relevant.
Doesn't really help.
It's something the judge knew because he had it before him.
Well, it supported his conclusion, didn't it?
Yes.
Yeah.
Sorry to interrupt, Mr. Solomon. May I ask a further question, please? You were saying that the claimant's evidence dealt with whether this clause was standard for various types of people.
Yes.
Did the claimant's evidence not deal with the necessity for the clause in any respect?
With the necessity?
The necessity for the clause?
Yes, it did.
Right, okay.
So there was evidence that the claimant said that they had a legitimate interest to protect and that the clause was necessary, i.e. a garden leave period followed by up to 12 months.
Yes.
Right. They did have that evidence.
And there was that evidence before the court.
Right.
But my submission is that, short submission, it's obvious that a year's garden leave followed by a year's non-compete is, to quote Lord Justice Bean in the commission hearing, piling Pelion upon Ossa and is obviously unenforceable.
But whether the clause is necessary will depend, won't it, on the judge's findings at trial about the extent of the legitimate business interest and the extent to which it reasonably needs to be protected, won't it?
Well, we respect that's and my submission is that it isn't, that this goes beyond what evidence could possibly justify.
No evidence could possibly justify a 24-month period of...
Right. All right.
We say it's plainly, it's not seriously arguable that a 2-year restraint in effect will succeed at trial. Thank you.
Thank you very much, Mr. Simon. Yes, Mr. Gray.
Just give me a moment, please. So long as it's convenient to the court, and before turning to the grounds of appeal, I want to make some short submissions about context.
Yeah.
And then to make some observations, please, about the judge's reasons for ordering expedition and why he was plainly entitled to, and indeed right, to order a speedy trial. My ladies, context is key. This is an appeal from a case management decision. The cases are legion in which the appellate courts have made clear the circumstances in which an appellate court will interfere with a decision of a court below. That terrain, frankly, is so well traversed that I needn't trouble you with it. But can I make 3 short further points about context? First, and as this court has made clear, the starting point or primary remedy for breach of a restrictive covenant or a potential breach of a restrictive covenant in the employment arena is an injunction. And the court will be familiar with the well-established principles or reasons for that, including that damages will rarely or will invariably not be an adequate remedy for breaches of such covenants, because the damage potentially sufferable by the covenantee will usually be unquantifiable. and because damages will rarely, if ever, be an adequate substitution for an injunction. Second, although an allied point, the courts, again including this court, have repeatedly recognised that claims in respect of restrictive covenants in the employment arena, and particularly, although not exclusively, claims for injunctive relief to enforce those covenants, fall within a particular category of claim that are urgent. Third, a speedy trial can take place, in this case, at a time where the large majority of the period of the covenant is still left to run. There will still be a further 9 months of a 12-month covenant left at the time of trial. My ladies, had the judge concluded, turning to his observations and the reasons for his decision, but had the judge concluded that all of the damage that could be suffered by the claimant would be suffered by the time of a speedy trial, and had the judge concluded that the consequence of that was that there was no prospect of the court at trial granting injunctive relief, there might be some basis for an argument that he should then have decided not to order a speedy trial. But the judge plainly did not reach either of those conclusions. To the contrary, and as he was entitled to do, he concluded first that all the damage that could be suffered by reason of Mr. Couture breaching his non-compete covenant would not have been suffered by the time of a speedy trial. And he plainly considered, second, that there was a real prospect of the court granting injunctive relief. And can I take you, please, in that regard first to the original note of the judgment, which is at tab 5 of the core bundle, page 73, and I'm doing it in this order for a particular reason that I hope will become clear shortly.
Does that start at page 61?
My lady?
Yes. Sorry, it's just I've taken it out of the bundle.
Yes. As you'll see right at just under the tram lines, that the note made clear it wasn't intended to be and wasn't a verbatim transcript, and in various places it simply set out the gist. But if I can ask you please to turn to page 73. The judge says there that Mr. Couture's evidence was that much of his work in the first year will not in fact be competing or trading, but involve the developing the technology to trade. So the judge clearly had in mind that although there might be some damage in Mr. Couture starting, not all the damage would be suffered either on the day that Mr. Couture started working or by the time of a speedy trial. And the self-evident consequence of that is that there would be utility in an injunction restraining Mr. Couture from working for Verition, even absent interim injunctive relief. And that is also clear from what the judge said when refusing Verition's application for permission to appeal against his order for expedition, which Mr. Solomon took you to. If I could just ask you to turn back to that, please, at page 94, tab 6 of the core bundle. Where the judge says, I made the order principally because according to D1's evidence, sorry, so tab 6, sorry, page 94.
Yeah.
It's the core bundle.
Oh, in the core bundle.
Yes,
That's
I'm so sorry if I didn't.
Sorry. Very slow. I do beg your pardon.
I apologise if I didn't.
No, it's my fault. Yes.
And it's the top box, but the second item.
Yeah.
Where the judge says, I made the order principally because according to D1's evidence in his first year of working for D2, he would not be engaged in any trading, so that a speedy trial could resolve whether the covenant was enforceable before then. And he then referred to the arguments made by Verition that he shouldn't have made the order given the delay and other factors, and he rejected those. And in making clear that Mr. Couture's evidence was that in his first year of working for Verition, he would not be engaged in any trading and that a speedy trial could resolve whether the covenant was enforceable before then, the judge clearly concluded first that not all of the damage that could be suffered by my client would have been suffered by the time of a speedy trial. And that effectively also dealt with delay, because although the delay had resulted in his not granting interim injunctive relief, the delay did not mean that all of the damage that could be suffered by the claimant would be suffered by the time of the speedy trial. And Mr. Solomon didn't answer the question, at least initially put from my lady, Lady Justice Laing, about further damage, whether there would be further harm after day one. I think in the end he accepted that there was no evidence to suggest to the contrary. And the judge clearly had in mind that not all damage would be suffered on day one. And second, he clearly had in mind that the court may well grant injunctive relief at trial. That is clear from his reasons for refusing the application to appeal to this court. The judge knew, indeed he had earlier referred in his judgment to the fact that a speedy trial could be accommodated in late June. And he knew that the non-compete covenant would not expire until the end of March 2024, so that an injunction would still be effective for the large majority of the period of the covenant still in issue by the time of trial. And of course, one can add to that the point made by my lady, Lady Justice Laing, that unless he is restrained by the court by way of an injunction, each day that passes, Mr. Couture will be getting the benefit of and building on his continued unlawful conduct. And we respectfully submit that the judge was entitled, and indeed plainly entitled, to reach those conclusions. I've addressed matters in that order, taking you to the note of judgment and the reasons for refusing permission first, because of the serious criticism that is made by Verition in the note that we received on Monday afternoon about the judge's approved judgment. And Verition now effectively says that in the approved judgment, the judge has made significant changes in his reasons for ordering a speedy trial. That those changes do not reflect the terms of his oral judgment, and that he has made those alterations knowing full well that Verition had appealed against his order, that he didn't have them in mind, and as I understand it, that it would be improper not to, or to refer to matters later that he didn't have in mind and that he wasn't acting judicially. We respectfully submit that those criticisms are entirely unfounded. My lady, if you turn to paragraph 52 of the approved judgment, which is, if you've got it, page 274 of the supplemental bundle, I'm not sure whether, it seems like you both have it loose. And if I just ask you, I mean, I appreciate you've read that, but if you read that against the background of what I've just taken you to, one asks rhetorically, what is new or different? And the answer is substantively nothing. The reasons in the approved judgment are entirely consistent with, reflective of, and substantively the same as the reasons that I've just taken you to. There is reference to no prejudice having been suggested, which was essentially neutral. But prejudice as a factor wouldn't impact on the reasons for ordering expedition. If anything, prejudice would have been a factor that might have weighed against an order for expedition, but there was none. And if and insofar as the complainant, the judge expressly referred to the case of Petter, again, there is nothing substantively different, and there was no basis for assuming that he hadn't taken into account the relevant principles in any event. So even if it's right that the wording in the perfected judgment is different, those reasons are not only consistent with, they are substantively the same as the reasons given by the judge on the 28th of April. My lady, Verition, I don't know whether I need to deal with this. Verition handed up, I think, or at least provided with its note on Monday, the Court of Appeal case in Day and Harris.
Yes.
My lady, just two points about that. First, that case concerns an entirely different set of circumstances in which what appears to have been a full and careful oral judgment was given the day after a trial finished, so rather less off the cuff than this. And then fully 6 months later, he added a passage containing a finding of fact on a controversial issue which hadn't been made at the time. Even then, the court did not conclude that the amended passage should be given very little weight, as Verition asserted this court should do in its note. To the contrary, in the passage that's actually relied upon by Verition, it's paragraph 80, I don't think you need to turn it up unless you want to, Lord Justice Lloyd said it was unfortunate that the judge had added a passage, adding a finding of fact, and then simply recorded without comment the appellant's argument that less weight should be attached to that finding than if it had been part of the original judgment. So it's not support for that proposition, it simply records the argument. But even if the judge did change his reasons, which he didn't, there would be nothing problematic about it. My lady, we've got the case of Bath and Escott. I wonder whether I could just hand that up. The principles, I'm sure, will be extremely familiar to you. This is actually a judgment of His Honour Judge Paul Matthews, sitting as a judge of the High Court, but I hand it up because it's actually quite a helpful summary of the principles.
Mr. Solomon's had a copy.
Yes. And my lady, I imagine this will be familiar to the court, but perhaps I could just ask you, please, to read paragraphs 6 to 8 rather than me have them read them out to you. And then finally at paragraph 12, where the judge referred to the fact that this court can, of course, ask a judge below to amplify their reasons. Self-evidently, if that can be done permissibly, even if there was some amplification here, there would be nothing improper about that. But as I say, ultimately, this comes down to a simple point that the judge didn't make any significant changes in his reasons for ordering a speedy trial. And the criticisms of the judge by Verition in that regard are, in our respectful submission, both wrong and regrettable. The judge was entitled to reach the conclusions that he did, including that all the damage that could be suffered by my client wouldn't be suffered by the time that a speedy trial could be listed, and that the court at trial may grant injunctive relief. But even if he had concluded that there was no prospect of injunctive relief being granted, he would still have been entitled, in the exercise of his case management powers, to order a speedy trial.
Because it would have limited the period of damages, or why? If there was no possibility of injunctive relief.
Yes.
Why?
So that the parties knew where they stood. And can I just take you in that regard? I mean, that is essentially what happened in Petter. You've probably seen that. So Petter and EMC, that was a case involving a non-compete covenant in which the employee, Mr. Petter, sought effectively a negative declaration that a covenant wasn't enforceable in circumstances where no injunctive relief was being sought against him. And even though his employer hadn't even threatened a damages claim, albeit it had not given an undertaking that it wouldn't. And Mr. Petter effectively said, look, I want to know where I stand. And the court at first instance essentially took the view that his desire to know the position for certain was itself sufficient to justify the order for a speedy trial. The Court of Appeal upheld that decision.
But I think I'm being a bit slow about this. If, as I understand it, there isn't a pleaded claim for damages. So,
But by amendment there, yes, but I agree. At the time
yeah,
there wasn't.
at the
yes.
time there wasn't a pleaded claim for
Yes.
damages. So,
Yes.
I'm not sure this is such a good point.
My lady, that may be right.
Okay.
My lady, it may nonetheless just be worth turning it up just to see some of the echoes of the appeal grounds that are pursued here, please. First of all, at paragraph 4 of the judgment, sorry, this is Authorities tab 24.
We're going to Petter now.
Yes, I'm so sorry. At paragraph 4 on page 399, you'll see the reasons of the judge at first instance which were expressed shortly and without reference to any authorities. At paragraph 5, the grounds of appeal pursued by the employer in that case, you'll doubtless immediately recognise the echo of those advanced by Verition on this application. My lady, paragraph 10, which illustrates the point that the courts have repeatedly recognised that restrictive covenant cases, particularly those involving claims for injunctive relief, are a particular category of case that is urgent. In that regard, referring to Lawrence, David and Ashton and Alliance and Prestwich, the court may recall that in the latter, Lord Justice Mummery effectively said restrictive covenant cases are urgent, and in Lawrence, David and Ashton, this court effectively said where a speedy trial can be arranged, an employee should really seriously consider just giving undertakings over to a speedy trial. Paragraph 18, I take you to this, given the second ground of appeal. Again, you'll see echoes of ground 2. And when we come back to look at ground 2, we will respectfully invite you to reach the same conclusion for essentially the same reasons. And we respectfully submit the justification for a speedy trial was very strong here. My client certainly wants to know where it stands and whether this non-compete is actually enforceable. In his skeleton argument in support of this appeal, Mr. Couture made clear that he didn't appeal against the order for an expedited trial because he considered that it provided an opportunity for a swift and final resolution to the proceedings. So Mr. Couture wanted to know where he stood. That's paragraph 10, page 4 of his skeleton. But this is a claim which goes substantially beyond the parties knowing where they stand. This is a case in which, if successful, the claimant will be entitled to restrain Mr. Couture from working for Verition and to continue to act unlawfully until March of 2024. And in essence, it is, in our submission, a case which falls directly into that category of claim which the courts have repeatedly recognised is urgent. So there is plainly a good reason for expedition. Restrictive covenant cases are urgent. There were no grounds for thinking that expediting the case would interfere with the good administration of justice, and to the contrary, King's Bench listing had made clear to the parties that it could accommodate a speedy trial later this month, and it's done so. No prejudice was advanced, and there were no other special factors that meant there shouldn't be expedition. Delay did not outweigh expedition in the same way it didn't in Gore and Geox, which you have. I don't ask you to turn it up unless you want to, that's Authorities tab 8, but where Lord Neuberger made clear that it would be disproportionately penal in that case to refuse an order for expedition because of delay in that case, which was of 5 months, I think. But in any event, delay as Mr. Solomon accepts, is not a relevant factor at trial. If we're entitled to enforce the covenant, then our primary remedy is to keep Mr. Couture out. Mr. Solomon said, well, there's no case in which that's ever happened before. Well, quite apart from the fact in our respectful submission, each case has to be determined on its own facts. And we know, for example, from Petter that expedition is ordered sometimes even when no relief, injunctive relief is sought. But there is, in fact, a case in the bundle, just so you've got it, it's tab 11, it's the case of OTS, in which injunctive relief wasn't granted, but there was a speedy trial. You can see that, it's, sorry, tab 11, page 170, paragraph 89. It's a judgment of Mr. Justice Christopher Clark. And you can see it really in the first sentence. That being so, it seems to me the appropriate course to take is to make no order now which restrains the defendants from carrying on such business or from solicitation, but to order a speedy trial. There we are. I mean, it's, I entirely accept that's a decision made on its own facts in the same way that this one. And one could test it another way. What if you don't know that an employee has started in breach of a covenant? Is it then to be suggested that you wouldn't be able to come along and ask the court for a speedy trial? Or if you'd agreed with an employee that they'd do job X, and in fact it transpired they were doing something other than job X, again, why wouldn't you be able to come along and get a speedy trial, even if at that stage you may not be able to hold the employee out from working given the status quo? Can I then turn, please, to the 4 grounds of appeal and ask you, please, to turn up, first of all, tab 1B of the core bundle, or tab 1 of the core bundle at page 14. Yes, please. 1-4. I'm so sorry. 14, 1-4. Sorry, if you don't have tabs, I'm sorry, that's not very helpful. So
Sorry, what are you, I've taken some documents out. What are you referring to?
I'm looking at the grounds of appeal, my lady.
The grounds of appeal. Yeah.
So the first ground of appeal is that the judge erred in making the order for expedition in the light of 2 particular matters. First, the judge correctly held the claimant had been guilty of unexplained and stark delay. And second, that had the claimant brought the claim earlier, there would have been no need for expedition, nor any injunctive relief. So 2 assertions are made about the position if Jump hadn't delayed and had brought its claim earlier. No need for expedition, no need for injunctive relief. But each and both of those assertions is simply wrong. And in respect of the assertion that had the claim been brought earlier, there would have been no need for expedition, can I remind you, please, of the chronology? On Mr. Couture's own case, and as is set out in the agreed chronology, that's page 51 of your bundle, it was on the 17th of November 2022 that Mr. Couture informed the claimant that he was intending to start at Verition on the 3rd of April 2023. And this is important, it's omitted from paragraph 35 of Verition's skeleton, and it was omitted when Mr. Solomon took you to this today. And that he considered the non-compete to be unenforceable. Now, we of course accept, as we did in the court below, that the claimant could at that point have taken steps to commence proceedings in order that they would come on before the 3rd of April. And the 4-month, whatever it was, 4.5-month delay before the claimant actually did so was essentially what led the judge to dismiss the application for interim relief.
Yeah.
But on any view, even if the claimant had commenced proceedings in November or December, there would still have had to be a speedy trial. And so the assertion made by Verition that there would have been no need for expedition is simply wrong. And more than that, it is contrary to what the judge found. And if you pick up, please, his judgment, starting at paragraph 40, just to orientate you, paragraph 40 is effectively where the judge turns to the balance of convenience. And then at paragraph 43, just 4 or 5 lines down, he says, secondly, on the 17th of November, D1 wrote the letter to Mr. Diener saying he didn't believe the non-compete clause was enforceable. And then the judge said there were 2 critical issues about delay. That's at paragraph 44.
Yeah.
And the first is the one that I draw your attention to. He says, if an application had been made earlier, an expedited trial could have been arranged before the first defendant started work, and there would have been no need for interim injunctive relief. So the judge rightly recognised that even if the claim had been commenced earlier, there would have had to be an expedited trial. And so the assertion in this ground that had the claimant not delayed, there would have been no need for expedition is wrong. It's contrary to the conclusion reached by the judge, against which there is no appeal. It's also contrary to what Verition said in its skeleton argument on the interim injunctive relief, where it recognised there would have to have been an expedited trial. And then the second of the 2 points advanced in ground 1, on which this is based, that if the claim had come on earlier, there would have been no need for injunctive relief. Well, we make 4 points about that. First, this is an appeal about expedition. It's not about the nature of the claim to be expedited. Second, although an allied point, Verition seems to be suggesting that had the claim been brought earlier, then it could have been limited to a claim for declaratory relief. But even if that were right, which it isn't, that claim would still have had to have been expedited, and Verition doesn't suggest to the contrary. Third, whether the claimant would have needed to bring a claim for injunctive relief is, as a matter of principle and logic, nothing to the point. The claimant would have been entitled to bring a claim for injunctive relief, and it would have done so, as it in fact did. And fourth, in any event, the claimant plainly would have needed to bring a claim for injunctive relief. And that is not least because, in the usual way, there are 2 central issues in this litigation. The first issue is whether the covenant is enforceable. And I accept that, of course, could be dealt with as a declaratory relief question, but that is only a stepping stone to the second issue, which is whether it should be enforced, which is very much an issue here. And can I make that good, please, by asking you in the core bundle to turn up Mr. Couture's defence, which you'll find if you've got tabs behind tab 8, and ask you please to turn to page 128. Just at the foot of the page, there's a heading, will any of you, page 128, sorry, relief sought. Paragraph 67, as the non-compete covenant is unenforceable, no injunctive relief should be granted. So that's effectively issue 1. But then over the page at paragraph 68, you'll see that he pleads, if which is denied the non-compete covenant is found to be enforceable, it's averred that the court should not exercise its discretion to grant injunctive relief. In other words, his position is that even if the court were to declare that the covenant is enforceable, he wants to continue working at Verition, not be prevented from doing so. And so this case is, and indeed has always been, about whether the court should enjoin Mr. Couture from acting or continuing to act unlawfully. So the second assertion on which the ground of appeal is premised, namely that there would have been no requirement or no need for injunctive relief, is also wrong. My ladies, Verition then seeks to rely upon two further matters in its skeleton argument that go further than its grounds of appeal. The first, made at paragraph 40, is that the order for a speedy trial causes it prejudice. But that is a false point, because there would have been a speedy trial even had there been no delay, for the reasons that I've just shown you. In any event, the prejudice that's now relied upon by Verition was not relied upon before the court below, and that is perhaps unsurprising given that Verition was seeking a speedy trial in the event that interim injunctive relief was granted. But in any event, having not raised those matters, the complaint now made at paragraph 40 of its skeleton, the judge failed to consider them, is entirely unfair. But the points of prejudice are in any event bad. The first is that a speedy trial leads to increased cost and pressure of the legal team. Well, the point goes nowhere in circumstances where, even absent any delay, there would have been an expedited trial. But as Lord Justice Voss said at paragraph 23 of his judgment in Petter, that is of limited importance where a well-resourced corporation is concerned, as indeed Verition is, as reflected by the fact that it's instructed lead-in and junior counsel and Paul Hastings. And the second point of prejudice that's advanced is that there's less opportunity for settlement. Well, in my respectful submission, the delay means that the parties have had more, not less time, to seek to resolve their differences, and they haven't been able to do so. And we respectfully also submit that arguments about prejudice in any event fall ill from Verition's mouth. Mr. Couture has not sought permission from this court to appeal against the order for expedition. This application is made by Verition and Verition alone. Mr. Couture lodged a short skeleton argument supporting the application, and he informed the court that he had applied to the court below to vacate the speedy trial. In fact, he has now withdrawn that application. So far as Mr. Couture is concerned, he is proceeding in accordance with the judge's order for expedition, and he doesn't appeal against it. Now, ordinarily, that may not matter a great deal, because one defendant would be entitled to make the application even if it affected the other. But the position is peculiar here, because my client, as Mr. Solomon has told you, has made clear that it is no longer pursuing the claim for injunctive relief against Verition. That claim is being pursued against Mr. Couture alone. If the claim for injunctive relief against Mr. Couture fails, then that's an end of the matter. And if the claim for injunctive relief against him succeeds, then Verition will be bound by the order as any other third party would be. So Verition doesn't need to attend a speedy trial, and indeed that is exactly what it said to us on the 10th of May. And can I just ask you briefly to turn that up, which is, it's the supplemental bundle, page 254, please. Just to give ladies the context, which you can see right at the top of the page. We had at this point served or sent draft amended particulars of claim which withdrew effectively the claim for injunctive relief as against Verition, and it made clear effectively that claim was only being pursued against Mr. Couture. And then there were other amendments it proposed to make, and we don't need to get into, I think, the detail of that, really. I think the suggestion effectively being made was that those issues should be hived off, but I appreciate that that's not a matter for the court now. What I really want to take you to is at page 256.
So these are solicitors acting for Verition.
Yes.
Yeah.
I'm sorry, I should have made that clear. And at 256, the anti-penultimate paragraph starting further, or the third paragraph down, further in any event, given your client's claim against our client has now been withdrawn, please confirm you agree there is no basis for continuing with our client in the expedited process. They say to the extent your client wishes to continue bringing claims against our client, those were the other claims, the proposed amended claims, we propose that they are stayed. Now, I accept Verition has changed its mind about that and is now insisting on taking part in the claim for injunctive relief, notwithstanding the fact that the claimant is not pursuing that claim against it. Apparently on the basis that it's still formally a party and that it wants to attend and participate in that claim as a party, to cross-examine and make submissions and such like. Well, the extent of any participation will ultimately be a matter for the trial judge. But it might be thought somewhat peculiar that this court is being asked to allow an application for permission to appeal against an order for expedition of a claim for injunctive relief that is not being made by the only defendant that actually needs to take part in the trial, and instead is being pursued by a defendant that doesn't need to take part in it, but nevertheless wants to, and now seeks to assert that it's prejudiced by that decision. And my lady, that in many ways explains the trial timetable, why D2 isn't included. But frankly, if D2 does take part, that shouldn't make any difference to how long the trial takes. There's not going to be duplication of the same submission. If both defendants take part, they'll need to work out how to divide the case between them. And if one of them wants to take one point or cross-examination of one witness, then that's what they'll do. But we're not going to have cross-examination twice. But in any event, we respectfully submit that the points of prejudice now advanced are not well founded. And the second point made by Verition that goes further than its ground of appeal is the assertion that the judge was bound to refuse the application for expedition because he had refused the application for injunctive relief, and precisely the same factors apply in precisely the same way. That's paragraph 39 of its skeleton. But even if that argument were open to it, given the grounds of appeal, it's clearly wrong. And can I just give you two obvious examples as to why delay doesn't operate in the same way in respect of interim injunctive relief and expedition above and beyond the one that we've already canvassed in relation to delay not being a relevant factor at trial. First, the claimant had no entitlement to interim injunctive relief, but we do have an entitlement to litigate the covenant. And the only question that then arises is as to the speed at which it should be litigated. So the lens through which the court is looking in respect of each application is different. Second, in refusing the application for interim injunctive relief because of delay, the judge had regard in particular to the atrophy of Mr. Couture's skills if an injunction were granted, but the claimant then lost at trial. An interim injunction were granted, but the claimant then lost at trial. But that plainly is not material to the question as to whether there should be a speedy trial. But in any event, the judge was entitled to take the view, as he did, that the claim should be expedited, notwithstanding delay in commencing proceedings for the reasons that he set out. The second ground of appeal is that the judge applied the wrong test in ordering a trial. That effectively is a repetition of that pursued by EMC in this court in Petter. As I showed you in Petter, the judge at first instance had been referred to the relevant authorities and principles. He didn't refer to them. He stated his reasons briefly. The Court of Appeal made clear it didn't consider that there was any basis for the contention. The judge had overlooked those matters and he was fully entitled to give his reasons briefly. All the more so, as my lady said, at the end of a long day, having dealt with the more substantive issue in some detail. And we respectfully invite this court to reject the same submission made by Verition as was made by EMC for the same reasons. save, of course, the position here is even stronger, inasmuch as the judge expressly referred to Petter in his approved judgment. And I think Mr. Solomon accepts that he had the law in mind and that the law had been set out to him. The third ground of appeal, Verition asserts there was no basis for expedition because on the claimant's own evidence, the cat would be out of the bag as soon as Mr. Couture started work for Verition, and it follows that there was no need for a speedy trial, which seems to overlap with the second part of ground 2, that the judge approached the case by considering whether any trial could take place before there was any material harm to the claimant, notwithstanding the fact that was contrary to the claimant's evidence. If Verition's right about ground 3, then the assertion that the judge approached the case on the wrong basis would be immaterial. The real point would be that the judge should have concluded that all the harm would be suffered on day 1. There was no material harm that Jump could suffer thereafter. Three short points about that. First, Verition has to make the phrase, the cat would be out of the bag, do an awful lot of work. And in effect, that it meant, and indeed could only have meant, that the claimant's position before the court was that all of the damage, all of the harm that it would suffer by reason of a breach of covenant would be suffered on day 1, as it asserts at paragraph 43 of its skeleton argument. But that is unreal. It was not what was meant by the submission. The phrase used by Mr. Laddie once in 36 pages of submission, where he was asked about adequacy of damages and said the risk to the claimant lies in the use and abuse, witting or otherwise, of its confidential information. Once the cat is let out of the bag, there's no stuffing it back in, and you've seen the evidence of Messrs. Dina and Lafitte talking about the value of the claimant's business and running into hundreds of millions of dollars. Well, that is not saying all the damage is going to be done on day 1. And then at paragraph 41...
No, because once the cat's out of the bag, it's marauding around the place
yeah, well,
for an indefinite period,
yes,
potentially.
Yes, my lady, doing more damage, knocking over vases as it goes. And then the quotation from Mr. Dina's evidence, can I just ask you please to turn that up? It was in the supplemental bundle, tab 1, page 17. At paragraph 44.
Can you just give me the reference again?
Yes. Supplemental bundle, tab 1, page 17, paragraph 44, please. And what is there said, if the injunction sought by Jump isn't granted and Mr. Couture commences work in breach of the non-compete covenant, the potential harm to Jump's competitive position, if he uses confidential and proprietary information in that role, emphasise those words, is likely to be immediate, substantial, irreparable and impossible to quantify. So far from saying all the harm would be suffered on day 1, the point that was being made was that if Mr. Couture used confidential information whilst carrying out that role, not on day 1 and ending on day 1, but from day 1 and continuing from day 1, the harm would be immediate, substantial, irreparable, and impossible to quantify. Each time he uses confidential information, he's causing serious harm.
Because he's not going to use it all on day 1.
No, exactly right, man. But second, and in any event, the evidence from Mr. Couture was to the effect that there would be little, if any, harm to Jump from the work that he would be doing until March 2024. It's striking that no reference is made to that evidence in Verition's skeleton argument. It's essentially airbrushed out of the material before the judge. But the judge relied upon, in his judgment and in his reasons for refusing permission to appeal against the order for expedition, Mr. Couture's evidence about the nature of his work. And the judge effectively relied upon that evidence for the purposes of his decision, and he was entitled to do so. And indeed, Verition doesn't appeal to this court on the basis the judge misunderstood Mr. Couture's evidence or that he wasn't entitled to rely upon it. And we respectfully submit that it's hardly surprising that it hasn't done so, because Verition's own evidence was consistent with Mr. Couture's evidence. And in that regard, can I just ask you please to turn up in the supplemental bundle tab 3, page 31, where you have the evidence of Mr. Vizecki, the Senior Managing Director of Global Quantitative Strategies at Verition. And if you look please at paragraph 33, can I just ask you please to read perhaps yourselves paragraphs 9 and 11 of Verition's own evidence.
At least a year to build it up.
Entirely consistent with the evidence of Mr. Couture. And then, sorry to jump around, but could I ask you to pick up Mr. Couture's defence, just a last reference on this point, please. In the core bundle, tab 8, paragraph 55, which is on page 126. Where he talks about, or he sets out his proposed role, what he'd be doing for the first 12 months. And then in the penultimate sentence, about 4 lines please from the bottom, he says this will eliminate, alternatively substantially reduce the risk of misuse of confidential information if the court were to find that information remains confidential.
I'm so sorry, Mr. Craig, I didn't get the page reference.
No, I'm so sorry. That's my fault. It's core bundle page 126, please.
126, thank you.
And it's paragraph 55. So, Mr. Couture's defence recognises that there is a possibility he will be using information during that period, although he says, given the role he's doing, there'll be a lesser risk, or given what he's doing. And then finally, just dealing with the second part of ground 2, that the judge approached the case on the basis as to whether a trial could take place before there was any material harm to the claimant. Well, Verition doesn't assert that the judge said that, or said that's how he was approaching matters. That's unsurprising because he didn't say that. So this appears essentially to be an argument that one should infer that that is what the judge did. But there is no proper basis for that inference, not least because the judge plainly recognised that there may well be some harm by the time of a speedy trial, but that even so, an order for injunctive relief would restrain further harm and further unlawful conduct. The marauding cat might be put back outside. Can I then please turn to the fourth ground of appeal, that the judge erred in holding that there was a serious issue to be tried as to the enforceability of the covenant, and had he decided that there was no serious issue to be tried, there would be no order for a speedy trial.
Yeah.
We make 4 points of broader principle about that, both as to the approach in principle and how these matters should be determined, and then I'll turn to the points that are made. First, this is an appeal against an order for expedition. It is not an appeal against the order to refuse interim injunctive relief on which Verition succeeded, far less against the reasons for that order. And the question as to whether there was a serious issue to be tried was a matter that the court was required to consider in respect of the application for an interim injunction on American cyanamide principles. The judge found that there was, but he dismissed the application for interim injunctive relief because of delay on balance of convenience grounds. And having won that application, we respectfully submit it's not open to Verition to appeal against the reasons for it. Appeals are against orders, not reasons. Second, applications for expedition are generally short and uncomplicated, and it would, in our respectful submission, be unattractive if the courts were to encourage litigants to engage in substantial disputes on the underlying merits of claims on applications for expedition, and in effect to suggest that a respondent to such an application would be entitled to launch by a side wind an argument tantamount to summary judgment, but without actually making an application. Third, Verition does not take issue with the conclusion that there was a serious issue to be tried on the width of the restraint. It takes issue with the 0 to 12 month clause and essentially says the judge could only have concluded that that provision was unlawful, seemingly as a matter of public policy, and also that the judge could only have concluded that the claim for a period of 12 months restraint after 12 months garden leave was so hopeless that there was no serious issue to be tried. And we respectfully submit, just as a starting point, that the argument that the 0 to 12 month provision is necessarily unenforceable as being contrary to public policy raises a serious issue. It is a factor, if anything, that militates, and indeed militates strongly in favour of a determination that it raises a serious issue, in much the same way as the Supreme Court, or indeed this court, particularly on second appeals, will sometimes allow permissions to appeal, or applications for permission to appeal, because an important point of public policy is engaged. And we also respectfully submit that if this court is to consider the issue as to whether a provision as to 0 to 12 months is contrary to public policy, it might be far better doing that after the matter has been fully ventilated at trial in the light of all the facts, with the benefit of a judgment of the judge at trial, rather than through a side wind on an appeal against expedition. And if the public policy argument really is to be litigated before this court, it would likely need a substantially longer time and proper consideration of materials from other Commonwealth jurisdictions. And you will have seen that we have put before the court in the supplemental authorities bundle authority from New South Wales and Australia, whereas I understand that the courts also have power to modify restraints where truly cascading clauses have been upheld as being enforceable. When I say truly cascading, there are different periods, different areas, for example, that are covered. And where those clauses have been upheld as being enforceable, both on grounds of certainty and reasonableness. And also the position, for example, in New Zealand, where the legislation makes clear that a court can modify restrictive covenants. Indeed, that legislation was referred to by Lord Wilson and Egon Zehnder and Tillman, where he made clear that a survey of the development in England and Wales of the severance principle would be deficient if it failed to note the current standing of the principle in other jurisdictions. That's paragraph 79. Now, we respectfully submit that those materials support the proposition that a clause providing for a restraint of 0 to 12 months is not unlawful as a matter of public policy at all. But I'm not sure I need to take you to those authorities, because really the point we're making is that they demonstrate that there is a serious issue to be tried. And further, and in any event, if the court is to consider public policy, a survey of the comparative jurisprudence might be helpful. And that is not best done on this application. Fourth, and even if serious issue to be tried does properly arise on the application for permission to appeal against the order for expedition, we respectfully submit that the judge was entitled to hold that there was a serious issue to be tried. There's no error of law in his doing so. Serious issue to be tried, as you know, is not a demanding test. It's a point made by the judge in his judgment at paragraph 21. where he said the serious question to be tried is not a demanding test, and the short time for hearing an interlocutory application is not the appropriate occasion to effect a definitive answer as to whether a covenant is enforceable or not. And that really reflects the second point that I made about on applications for speedy trials. Really, court doesn't want to get bogged down in arguments about merits in the same way as it doesn't on applications for interim relief. But in any event, the judge was clearly entitled to conclude that there was a serious issue to be tried. My lady, can I then turn, please, to the arguments on novelty and uncertainty to the extent that I need to develop them? I'm in your hands in relation.
I don't think we need you to develop them.
Well, my lady, I'm grateful. In which case, for all those reasons, we say there is no real prospect of Verition succeeding on its appeal. Each of its grounds is without merit. The judge was entitled to make the order that he did for the reasons that he did. And more than that, we respectfully submit that he was plainly right to do so. And the suggestion at paragraph 42 of Verition skeleton that he made the order as some sort of consolation prize is both unfortunate and wrong. And we respectfully invite this court to dismiss the application for permission to appeal, alternatively to dismiss the appeal, alternatively to hold that the judge was right to order a speedy trial.
Thank you very much. Mr. Solomon, do you think you can reply quickly? I don't want to limit your time, but if you can, we'd prefer to hear you now.
I think I can.
Good.
I've got 7 short points.
Thank you.
Hopefully in as many minutes. The first point is that my learned friend consistently said cases involving restrictive covenants are necessarily urgent. And he referred to various cases, including Lawrence, David and Ashton, a case in which Lord Justice Bolcom famously and notoriously said respondents to applications should consider giving undertakings before a case comes on for an interim hearing, and then have speedy trials following undertakings or injunctions, and they should discouraging contested interim applications. That's true in general, but all these cases need to be looked at individually. In this case, it's not urgent, and the reason it's not urgent is because of the claimant's delay. A claimant can't delay, wait until the 11th hour, and say it's really urgent because we haven't acted sooner. Secondly, I understood my learned friend to say even if there was no serious issue to be tried, there should still be a speedy trial. I'm not sure how far he pushed that position when my Lady Justice Laing asked him a question on it, but plainly that's wrong. He said that
I think the point he was making is even if there was no prospect of an injunction,
even if there was no prospect of an injunction,
there should still be
of the trial.
Yes, I think that was the point he was making, because there could be a damages claim, but I think he accepted that his current pleading doesn't include a damages claim.
Yes, and there was no submission below that the claimant is entitled to know the position for certainty reasons. Thirdly,
well, the claimant has a right to pursue a claim based on the restrictive covenants in a signed contract.
yes, it does.
Yeah.
But if it's been told that it won't get an injunction and its only claim is for an injunction, then it would be absurd to pursue it, and no court would grant a speedy trial in those circumstances.
Right.
I understand that to be the submission that my learned friend made and then I think withdrew or didn't push harder.
Okay.
The third point is that my learned friend said there was no grounds for thinking there was any interference with the administration of justice, and he said listing could accommodate it. This court will know, and indeed it's true in this case as I understand, that listing confirm if there is an order for a speedy trial, they will accommodate it. But that doesn't mean that there's no interference with the administration of justice. Listing isn't waiting round with empty court periods in the outside chance that someone will come on.
But my understanding is that the judge made some inquiries and asked whether,
The judge didn't, my lady.
or somebody made some inquiries and asked whether there could be a speedy trial accommodated.
Yes.
And the answer was
from
yes.
listing
Sometimes
was-
the answer is no.
Yes, the answer from
But the
listing
answer was
is
yes.
we will accommodate it if there is an order for expedition. But listing did not say there is nothing in the diary and no one else will be bounced out. And my submission is that's always the position, that the King's Bench Division is a busy division and will always have hearings. It's not waiting around for Jump on the off chance that Jump will seek expedition. And there's never going to be a case where you can get evidence of actual interference with the administration of justice. It obviously does interfere. Getting a speedy trial obviously does. The fourth point is that my learned friend said delay will not be a factor at trial, and I think he relied on the fact that I accepted that the status quo wouldn't be a factor at trial, but of course...
No, you accepted delay wouldn't be a factor in determining whether to grant an injunction or not.
If I did, I went too far. My submission is this, that Mrs. Justice Cox in TFS set out what is the three-stage approach to injunctive relief, and that was a trial. And then the fourth stage is discretion and whether or not an injunction should be ordered. And so at that fourth stage, the court can take into account the claimant's delay. And that's the point that my learned friend read out from Mr. Couture's defence, where Mr. Couture said, in any event, there shouldn't be an injunction because of the claimant's delay at trial. And so that is the point on that. The fifth point is that it was said that I conspicuously omitted to refer your ladyships in the chronology to page 51 that on the 17th of November Mr. Couture contended that the non-compete covenant was unenforceable.
Yeah.
I didn't refer your ladyship to the fact that there had been without prejudice discussions as from the 15th of July either, nor did I refer your ladyships on the 23rd of September. The claimant wrote to the first defendant saying that if he started work for the second defendant, that would violate the covenants. But it's obvious that the parties' positions, the respective positions, were that if you start work, Mr. Couture, you'll be in breach. And Mr. Couture was saying, I'm going to start work. I was not misleading the court by not referring.
No, we didn't
to that
understand that to be the position.
Secondly, it said against me that it was wrong for me to assert that in ground one that absent delay there would not have been any need for expedition. I made the point in my earlier submissions that had the claimant acted promptly, either in July 22...
But it would have been from the 17th of November, wouldn't it? That's the point. The claimant says, if you join Verition, you will be in breach, and doesn't get an answer until the 17th of November, when Mr. Couture says, I am going to because I think it's unenforceable.
Yes.
It's at that point that we're looking at what the claimant should have done. And at that point, there would have had to be a speedy trial, wouldn't there?
If at that point it had commenced arbitral proceedings.
But it didn't have to. It had a right to litigate in the courts. There was nothing that said it had to arbitrate.
The contract did.
What had to? They couldn't pursue a claim in the civil courts.
If your ladyship, I think the answer is it could seek injunctive relief.
Yes.
It could. It had the right to seek injunctive relief,
Yes.
but it would still go to arbitration thereafter.
Well,
it had the ability to seek injunctive
Yes.
relief, but it had the ability. It had the ability to seek arbitral proceedings.
but it didn't have to.
It didn't. Of course, it didn't have to. It didn't have to do
seek
anything.
an interim injunction,
It,
or bring proceedings for an injunction, and ask for a speedy trial.
it did.
And that's what it would have done. It is what's being said against you in November, given what it did do. And there would have had to be the same thinking around speedy trial in that period.
The point is this, if I can just make these
Yes.
points, I think in answer to that question, first, if it had brought arbitral proceedings in November 22, it could have organised with Mr. Couture for those to be held at the pace that
Maybe.
it wanted, with the arbitrator to be appointed.
Maybe,
So
yep.
it's different for an order to speedy trial. Second, there was no right at that if it brought an arbitration.
If,
Yes.
yeah, then
Had,
no
it,
right.
had it acted properly, as I say it should have done, it would have done this, and it wouldn't have brought a claim.
So it would have been
against-
improper, is what you're saying.
No, it could have done this, and this would have been the
But-
best way to act.
Okay.
And your ladyship this is all part of what the judge should have taken into account in exercising his discretion on
Can an
this.
arbitrator grant an injunction?
No,
Yeah, an
That's why
arbitrator
they-
can grant an injunction.
really?
Can they?
But it wouldn't have been any need for an injunction.
Can an arbitrator grant an injunction?
Taking it in stages, there wouldn't have been any need for any interim relief in an arbitration if it had been conducted promptly. Secondly,
Well, you say promptly, but arbitrations can take years.
you can but it's possible for the parties to organise themselves to do it properly, and it's possible for arbitrations to happen quickly.
Well,
It's
But
possible.
so what? I mean, if they've got the choice of going to court or arbitrating, why aren't they entitled to go to court?
They're entitled to. It's just that this is a relevant factor when the judge is exercising his
but
discretion.
why?
Why?
One of the factors that the courts consistently emphasise in speedy trials is the impact on other court users. And had it gone down this route, as it was entitled to, there would have been no impact on anyone else at all, including the second defendant, because it could have arbitrated speedily and resolved the process.
So could the judge have said, oh, I see you've got the option to arbitrate in the contract. I'm going to refuse you a speedy trial in order for a speedy trial because you should have arbitrated.
That would be
Would that be a proper exercise of the judge's discretion?
absolutely.
Really?
If the judge had said,
Right.
had you acted promptly in November 22 and sought a speedy arbitration, that would have resolved the need for the courts to grant an expedited trial in April 2023.
And therefore, I'm not going to grant a speedy trial on that basis.
Yes.
That
and-
would have been a proper judicial exercise of discretion.
Yes, it was. It would have been, because you could have acted promptly. It wouldn't have adversely affected any other court users, and indeed wouldn't have adversely affected the second defendant.
Okay.
The sixth point, my ladies, is that my learned friend said the claimant is entitled to bring a claim for injunctive relief and needed to do so. Of course, it's entitled to bring whatever claim it wants. It's not entitled to interim injunctive relief as an entitlement.
He didn't say that. He said there was a discretion in relation to interim relief, but he had a right to go to court
And there's
to
a
get a permanent
There's a
injunction.
discretion in respect of final relief as well.
Yes,
It's a very
he-
narrow discretion. It's much narrower than the
Once you've
discretion
established-
in relation to
Yeah.
interim relief.
And the second point is that my learned
See
friend said,
Doherty and Orme, which is referred to in Fannon and Gilligan. Anyway,
I accept that.
all right.
But the second point is that my learned friend said it needed to bring these proceedings. But had the claimant obtained an order from an arbitrator that the covenant was enforceable and could be enforced, then of course the parties would have complied with that. It's absurd to say because of its delay, and because the first defendant says that delay should disentitle it to a final order, had it acted promptly and got an order earlier, the first defendant would still have said it's disentitled to a final order. That's not what the first defendant's case is at all. Seventhly, my ladies, I think it's seventhly, My learned friend now says Verition don't need to attend at all the trial. He read out elements of correspondence. The correct position is that Jump has changed its position. It initially sought to amend and to include all the amended claims in a speedy trial. It now doesn't want to, and it now says it will withdraw against Verition, but the current position is it has not. The current position is Verition, for whatever reason, no need to Jump, remains a defendant to a claim that even it says it's not going to pursue. In any event, we are intimately affected by the relief that the claimant is seeking, the respondent Jump is seeking, and because of the way it's chosen to pursue this claim, including us, the defendant, are entitled to appear. And the last point is in respect of ground 4.
Yeah.
4 very short points on ground 4. My learned friend starts by saying it's not open for us to take the point on ground 4 because we're not appealing against the findings on no serious issue to be tried. That's wrong. What must have underpinned the order for a speedy trial is the judge's conclusion that there was a serious issue to be tried. It's inconceivable that there would have been an order for a speedy trial if there was no serious issue to be tried. So it's part of the order for a speedy trial. Secondly, my learned friend has said for the first time, as far as I'm aware, that it's wrong for us to take this point because we haven't applied for summary judgment.
Well, he said you're doing it by a side wind. To deal with it in this way is when actually what you could have done is applied for summary judgment.
Yes.
It is to do it by a side wind. It is a slightly odd way. You're attacking a case management decision for a speedy trial by reference to reasoning in relation to another
But if I'm right about the first point, my lady, it's entirely proper for me to do it by this route, and there's no obligation for us to do it by a different route. And furthermore, if I'm right on this, it's in everyone's interest. If I'm right on this, and your ladyships can determine this now, it's in everyone's interest that it is determined now. Thirdly, my learned friend says if it's contrary to public policy, it should be tried.
He says
no, if there's a dispute about whether it's
sorry.
contrary
If there's a your ladyship's right. That's the point I'm intended to make.
Yeah.
If there is a dispute about a covenant that is contrary to public policy, that the dispute is contrary to public policy, then that matter should be tried.
What he says is your argument amounts to a covenant in those terms is on its face and inevitably, whatever the facts, contrary to public policy.
Yes.
That argument raises a serious issue to be tried.
Yes.
That's what he says.
He's wrong in that respect.
What do you mean? Okay, go on, sorry.
The cases consistently say the first task of the court is to determine what the covenant means. And if the courts can construe a covenant at the interim stage, they should do so. And if your ladyships construe it in the way that I have urged on this court, then I say it is inevitable that you will consider this covenant to be wholly abhorrent and void.
Because it's contrary to public policy.
Because it's contrary to public policy.
Right, but that's the point that he says inevitably raises an issue to be tried. But you say we can decide it now.
And it is not suggested, it was not suggested below, and it is not suggested now that there is a single fact that could be put before the court that would deal with this. The claimant Jump knew that we were taking this point. It dealt with it very briefly in its skeleton argument before, and none of its evidence addresses why it needed a 0 to 12 month discretion. It simply addresses why 12 months is enforceable. It chose not to address this point. There was no evidence for the court. But what Mr. Craig has not told you is what possible evidence there could be to justify a trial on this. He's not suggested there would be any such evidence.
But I just don't understand. It's my fault, Mrs. Hall. I just don't understand this point. I think you've accepted that any employer can, at its discretion, waive the full force of a clause by saying, well, I know the clause says 12 months, but actually you're a nice chap and I quite like you, so I'm only going to say that you should be subjected to the clause for 6 months. There's nothing wrong with that, nothing contrary to public policy, and yet at the same time, if that's actually made express in the clause, suddenly it is contrary to public policy.
No.
I just don't get it.
That isn't my position, my lady.
Right.
The first proposition is correct, that any employer relying on a restrictive covenant lasting, say, 12 months can say 12 months is justifiable, but I only want to enforce 6 months.
Yes.
It's entirely open to the
Okay.
court to do that. The court wouldn't be rewriting the covenant, it would just be enforcing for the period that is justifiable. Secondly, it would be legitimate for an employer to have a covenant which said the covenant is for 12 months, but the employer retains a discretion not to enforce the entirety of the 12-month clause. That's nothing more than making express the position I set out in the first point.
Right.
But, and this is the key,
Yeah.
a proper construction of this clause shows that this clause is not such a provision. It's not a retained discretion.
But there's an argument about that, isn't there?
That's a construction argument.
Yes, but it's a serious argument that requires to be
No,
determined.
it's-
It doesn't require evidence, but it has to be determined.
It's a construction argument. It's a pure construction argument. And can I just show your ladyship one paragraph of one case on this? It's tab 7, TFS derivatives, page 80 of the authorities bundle. Paragraph 41, the judge expressly referred to the 4 stages in TFS. Page 80, paragraph 41. First stage then is construction of the contract, and then Mr. Justice Cox referred to Arbuthnot and the rulings, case in this court, and then Lord Justice Chadwick stated as follows, paragraph 20, first task of the court, faced with the contention of post-termination restraints, is to construe the contract. That, as it seems to me, is a task which the court ought to carry out on an application for interim relief if it can properly do so. Lest the court satisfied with disputed facts which bear on the construction, those facts can't be resolved without a trial. The court at the interlocutory stage is as well able to construe the relevant contractual terms as the court will be at trial. There's no need to put off until trial determination of the question, what do the contractual terms mean? The court can and should determine the scope of the restraints, which is a matter of construction, contractual terms seek to impose. That's the point I'm making.
And if the judge had reached the conclusion that what this clause does is what my lady suggested it does, then there would have been a question perhaps about whether it was or wasn't contrary to public policy. And there may have been arguments about that, and there may have been arguments in any event about its enforceability once a decision had been made about what it meant.
If the judge had reached the conclusion that in fact this clause is nothing more than a contractual discretion, a 12-month clause of the contractual discretion, my submission would have been that's wrong. That construction is wrong. That's a clear error of law, and that can be corrected by this court.
So instead of having a speedy trial that determines all the issues in one go, we'd have had one point hived off with an appeal to the Court of Appeal on that point before you even got anywhere near the question of determining the other issues. Is that what you're suggesting is sensible case management?
This is the only issue before the court.
The enforceability of the covenant is what's in issue at the speedy trial.
Yes.
And whether it should be enforced by an injunction.
Yes.
You're saying hive off this one small point about the meaning of the clause before you even get to questions of public policy, enforceability. And if I don't get the answer I like, I'm going to have a speedy appeal before we get to the speedy trial.
What I'm saying is this. Obviously, I'm not communicating as eloquently as I should. my first submission is that the construction of the clause is as I've suggested. It's not a discretion. It's a clause.
Well, you can see that there's some room for disagreement. We haven't formed any view, but there may be a different view about that.
There is room
But we're not deciding it
There's
because
room for-
that's for the speedy trial.
There's room for disagreement, but that is something the judge should grapple with. It's something that the judge dealing with an interim hearing should grapple with, and with respect, this court should grapple with. And if I'm right about the construction point, then it inevitably follows that this clause is abhorrent and void. That's my submission.
But even if you're right about it, there's an argument to be had about whether it's abhorrent and contrary to public policy, isn't there?
Well, my submission there isn't.
There's not even an argument.
No. No, it's plain.
So how did the judge deal with this point in the judgment?
He dealt with it at paragraph
Is it 29?
23 to 29, page 270 to 271. The conclusion is 29.
Well, so the judge, paragraph 27, he recalls Mr. Laddie's submission that he'd have to justify the maximum 12-month period. That seems to me correct. Well, that's type it. Seems to me to be correct in principle. It also contains within it the requirements for resolving the uncertainty. I mean, what's wrong with that? On the face of it, that reasoning seems to be perfectly sensible.
What's wrong with it, my lady, is that the clause doesn't require the employer to justify a 12-month period. It requires the employer to justify an unknown period from 0 to 12 months.
Well, I mean, you're repeating the points you've already made, but
Yeah.
all right.
All right.
Thank you.
All right. Thank you. Thank you very much. Just bear with me. We will retire for 5 minutes and come back in. Please don't go far away. Well, we are grateful to both council teams and the solicitors sitting behind for the assistance that you have given us today. This appeal was prepared with speed and dealt with by you both very concisely. We're grateful for that. We have concluded that permission to appeal should be refused. We will deliver our reasons in judgments to follow in the usual way. You'll receive them for corrections and typographical errors, but not for re-arguing the points. You will pay attention, I have no doubt, and will be well aware of the embargo at the top of the judgment, but I'm required to remind you of it in light of recent cases. The fact that we're not giving our reasons now should not stand in the way of getting on now with the speedy trial. The speedy trial order is upheld, and it's just a question of the reasons. All right?
Lady, I'm grateful for that. I've asked Ms Stone to address the court on the question of costs.
Yes.
If that's convenient.
Very well.
My ladies, your ladyships have refused the second defendant's application for permission to appeal. The normal position in this circumstance, as no doubt the court's well aware, is that costs should follow.
Yep.
We therefore ask for
Have you
our costs.
produced,
We have. May I hand up these?
was it exchanged?
It was yesterday afternoon at about 2:30, and I have here the schedules for each party.
Yeah.
As to the amount, it's unclear currently the extent to which the second defendant objects to any
Well,
particular-
Ms Stone, would it help if Mr Solomon just indicates whether he has an objection in principle or as to the amount?
Object to the application of costs following the event in principle.
Are you asking for a summary costs
Yes,
of the
yes,
appeal in
indeed,
any
ma'am.
event?
Summary assessments of the
A
cost.
summary assessment. You're acceding to that?
Yes.
Yes. All right. And as to the amount?
As I do dispute the figure.
You do dispute the figure.
Yes.
All right. Well, it probably help you to know which bits are disputed,
Indeed, my
and then
lady.
you can respond.
Thank you, Mary.
Thank you, my lady. Does your ladyship have the jump schedule in front of you?
Yes.
You will see that the fee earners' grades are set out at the top,
Yep.
and the hourly rates next to the
I've
grade.
got 2 copies. Should I have 2 copies? Is there a difference?
Is one Verition's cost schedule? my lady?
My lady, perhaps it was that you handed out both copies, each of you, for each of the parties, because there is one copy of each.
Yes, I've got
Yes. Thank you. Right. So we're looking at jump.
Yes.
Yeah.
So my first point is that whatever our cost schedule is irrelevant.
Yeah.
What your ladyship has to do is assess the reasonableness and proportionality of
Yeah.
Jump's costs.
Yeah.
So the fact that my learned friend has handed up our cost schedule is presumably to make points against our cost schedule, where that should just be ignored. It doesn't matter. Secondly, if your ladyship looked at the fee earners,
Yes.
you can see the grades
Yep.
and the hourly rates.
Yeah.
If your ladyship has the white book, the court has the white book,
Yeah.
2023,
Yeah.
the guideline hourly rates are set out at page 1435 in...
Did you claim guideline hourly rates?
no, we've claimed more.
You didn't.
No, we have claimed more than guideline hourly rates.
Right.
I've only got the 2022 version.
It's the same point. It's 44SC.31.
Can you give me the page number again?
It's 1435 of the 2023.
Thank you.
It might be easier if I just read them out. It's very easy. The point's very easy. Grade A for London Central London Solicitors 512, Grade B 348, Grade C 270, and Grade D 186, and that's about a third, or just under a third, roughly, of each of the hourly rates claimed.
And the hourly rates your solicitors have claimed are on a par with the hourly rates claimed by their solicitors.
Yes.
We should ignore that.
Yes. And not least because this point was taken by Jump when resisting the order for costs below, and the judge agreed with it and noted it and gave an interim payment on account, noting the excessively high hourly rates. So what's good for Verition is good for Jump, and the court should take into account the guideline hourly rates, and the fact that both parties are spending more than the guidelines simply means that both parties are claiming
it's their choice.
Their choice.
Yeah.
It's
Okay.
their choice.
So the judge ordered a detailed assessment and an interim payment.
With an interim payment, yeah.
Yeah. Okay.
50% of the claim on an interim amount of the claimed costs. That's what the judgment was. I don't have a copy of it to hand. Secondly, the third page of the cost schedule.
Yep.
Your ladyships will see that 6 hours each are claimed for A and B fee earners.
For attendance at
For
hearings.
attendance today. It
Yeah.
hasn't been 6 hours,
No.
but there's no need for both to attend. You'll see I'm accompanied by only one solicitor. And thirdly, if your ladyships turn to the penultimate page,
Yep.
your ladyships will see the council's fees. It's not broken down between different council, but it's 75,000 for today's hearing.
Yep.
2 points. One is that our total council fees are around 60,000. That's myself and a junior. She couldn't attend today, but she was instructed. But in any event, 75,000 for this hearing is plainly excessive, and something approaching half of that would be reasonable. So those are the 3 points I make.
So when you say 3 points, the first point,
Hourly rates.
the first point is hourly rates, and you say we should deal with all hours claimed on the basis of the hourly rates,
Well,
or around.
You-
It's a rough and ready assessment,
rough
but
and
we
ready
should have
assessment.
regard to that.
Exactly.
Okay. And then your
I'm
second
not
point is
saying
the
you should
solicitors.
apply those hourly rates. Sometimes plainly things are higher than hourly rates, but those guideline hourly rates are a guideline for a reason, and they've
Okay.
been updated recently. Secondly, the attendance and hours of solicitors here today,
Yeah.
only needed one isn't 6 hours, and thirdly, council fees.
Yeah. Thank you, Mr. Solomon. Yes, Miss Stone.
Thank you, my ladies.
Yes.
We disagree that the court has to disregard somehow Verition's cost schedule when looking at the question of proportionality. To the contrary, we think it's plainly relevant, particularly in circumstances where Jump's cost schedule is only a little over half of the costs incurred by the second defendant.
But that's
So
not to say that the court wouldn't have cut down
that
those costs as well.
Indeed, that is the case, although it is, of course, relevant to the question of proportionality, that both parties considers that significant costs should and have been incurred for the purposes of this application for permission to appeal. And we do agree that what's good for the goose is good for the gander when it comes to the question of how you should look at things like hourly rates. There are two components in the usual way to the cost schedule. The first is for solicitors and the second is for counsel. So far as I understand the submissions made on behalf of Jump, there is no complaint about counsel's fees, and therefore I will not address the court in relation to that.
I think he said roughly half.
Oh, did you? I'm so
Yes.
sorry, I missed that. Well,
Yes.
in circumstances where that is the case, I will refer to the fact that what Jump has sought in relation to counsel is in the same order as that sought by Verition. And in particular,
It's about just over 60, isn't it?
yes, just over 60, whereas jump is 75,000.
Yeah.
So we're in the same order, and that is nothing to the point. And furthermore, the extent of the amount that counsel fees have incurred in the course of this hearing is a direct result of the way in which Verition has put its case, in the sense that not only has it sought to appeal against expedition, it's also brought an issue, the serious issue to be tried point, and therefore the underlying merits of the enforceability points in relation to the covenant. So for those reasons, I say there can be no proper complaint about the amount of cost for counsel incurred in this case. Turning, if I may, your ladyships, to the question of solicitors, it is stark that the solicitors' fees incurred on behalf of Verition in relation to this appeal are 4 times those which have been incurred in relation to Verition. Theirs is at 82,486 in total, whereas ours is 21,148.75. In those circumstances, again, in our submission, it does not lie in Verition's mouth to say that our costs are unreasonable in circumstances where theirs vastly eclipse the sums that our client has incurred. As to hourly rates, our hourly rates are equivalent to theirs, and indeed their highest hourly rate of 1,375 exceeds the highest hourly rate in relation to jump, which was £1,301 an hour. So in those circumstances, we say that the fees overall incurred by jump are reasonable and proportionate in the context of this application for permission to appeal, and both as a matter in total and also on the individual elements as well. Unless I can assist further.
Thank you very much. We will retire and consider those submissions. Adopting a sorry, let me start again. We've considered the submissions made both by Ms. Stone on behalf of Jump Trading and the submissions made by Mr. Solomon, King's Counsel, on behalf of Verition. It seems to us that on a summary assessment of this kind, a broad brush approach is to be adopted, having regard to the questions of reasonableness and proportionality. We consider that the schedule of costs claimed by Verition demonstrates that this was a case that justified considerable input from both solicitors and counsel. There were difficult issues to be advanced on both sides, and that justified the time spent. But equally, we have had regard to the guideline hourly rate and consider that some adjustment is warranted. Adopting that broad brush approach, we consider that the costs claimed in respect of solicitor costs on a global basis should be reduced to £15,000, and that the costs claimed in respect of counsel fees should be reduced on a global basis from £75,000 to £70,000. So the total is £85,000 on this assessment. Is there anything else?
Presumably that's payable within 14 days in the usual way.
Yes.
Thank you.
Anything else?
No, my lady, I'm grateful. Would it be helpful if the parties agreed an order, which then sent it to your ladyships for approval for sealing, or does the Court of Appeal send one out?
I think what normally happens is when you receive the draft judgments, we invite you to agree an order setting out any consequential. But in fact, we've refused, yes. So actually,
Refuse permission and all
yes,
costs. Yeah, I think
yes.
even
I think that would be sensible. We will take you up on that offer, Mr. Solomon. Very grateful.
Okay.
Thank you. Thank you very much.
All right.
Do you have an email address?
Sorry?
Do you have an email address to send the order? Well done.
What on you?
I thought I was going to win after my submission.
That's your tips.
What's really disheartening when you get up and you just...
No. You think they'd make their mind up? Everything is absolutely amusing and laughable. But yeah,
You know what?
that's just my normal reception.
Not at all. You all know what it's like.
Shall I email you an order?
Maybe, yeah.
Exchanges. Thank you, well done.
Right.
That's for their approval, is it? It's marked for their attention.
Yeah, just send it.
Do you want us to take our papers out? That's probably easier for you, wouldn't it? Yeah. Okay. Can you give us... Yeah, you and me both, I've got to tell
And
you.
I've got a meeting at 2, so this will be
Okay,
fun.
we're going to get out very quickly. I'm just going to get the clerks to come. Let's,
No, I think we're okay. You're already set up. Do you want a hand actually? Maybe should I take one out? been on a bit, yeah. And also, thank you. Like I was saying before, that you could put the bundle together and leave it.
And that's nearly done, we'll get it.
No, I wasn't.
Hi, is that
heroes of
Tracy, hi.
So that's
Parks to come over
it's
here.
really, it makes
My
all the
picture
difference.
accounts.
So,
63.
thank
you very much. Bye.
You want this?
I'll grab it. Yeah, I've got 2 arms. Amazing. They work. Thanks very much.
Thank you.